Selwyn District Plan, and this morning we're going to commence proceedings with the karakia by Commissioner Solomon. Thank you very much for that. And next thing we're going to have is a health and safety briefing.
Thank you, Chair. So bathrooms can be found in the corridor directly behind me and also in the corridor over here as well. Event of a fire exit over in the corner there, also through the main two doors here, and the assembly places are either the car park, but to follow direction of any council staff, they'll be able to direct you where to go. With earthquake, it's the same story as always. Stay in place until it's over, then exit the building to those same assembly locations.
Great, thank you very much. And because it's day one of the hearing and we've got a very large panel here, we'll just quickly run through and introduce ourselves to you for the record. My name's Rob Van Voorthausen. I'm an independent hearings commissioner based in Napier in the Hawke's Bay. And we'll start now, Andrew, at this end of the table. Brief introductions, please.
Sure. Yeah, Andrew. Yes, Andrew Willis, independent planning commissioner based in Christchurch.
Yeah, Malcolm Lyle, Selwyn District Councillor, Deputy Mayor. I've been around the odd annual plan in the last 20 years.
Kia ora koutou, my name's Raven Solomon. I've sat on hearings before and I'm an independent commissioner and I'm looking forward to these hearings.
Kia ora, I'm Nicole Reid. I'm a councillor for the Selwyn District Council.
Marina, Gary Ray, independent planning commissioner based in Nelson.
Morena, Lindsay Daish, independent commissioner and planner, and I'm based in Wellington.
Tēnā koutou katoa.
Great, thank you very much for that. Just before I hand over to the first submitter on our schedule this morning, the 42A reporting team who are here this morning, do you want to briefly introduce yourselves to the room as well, please?
Good morning, I'm Robert Love. I'm the team leader for the strategy and policy team at Council and the author for the strategic directions chapter and 32 and 42A.
All right, thanks very much for that. And to the 42A officers, anything you wish to draw to our attention this morning before we hear from our first submitter?
There's not.
Okay. And just for the benefit of those present, if you haven't already caught up with the fact, as a panel, we've put any questions we had for the 42A team in writing prior to the hearing, and those questions have been answered in writing prior to the hearing. And I understand that information is available on the Selwyn District Council District Planning webpage. So if you haven't already had a look at that, that's where you'll find that information. In terms of hearing procedure, we have a schedule that's been drawn up, which we have copies available for you if you don't already have a copy. We'll proceed through that this week. We'll then adjourn this particular topic hearing, and the officers are going to do what's called a reply report for us, where they think about what they've heard during the hearing and let us know if they've changed their mind in terms of any of their recommendations to us. And I think the timing for that's roughly about 2 weeks post the end of the actual hearing. And at that stage, once we receive that reply report, we'll see if we have any further questions for the officers, and thereafter we'll deliberate on the particular topic that we're dealing with in each of these series of hearings. So without further ado, we call our first submitter, Kainga Ora. If you want to come up, we have a table for you. If If you need more chairs, just bring them up with you, that's fine. And so good morning and welcome. Just before you start, for benefit of yourself and all of the submitters, we thank you very much for pre-circulating your written material, legal stubs and evidence. We've read that material, so you'll be pleased to know you don't need to read that aloud to us. We're also a very large panel, so we're very conscious of being judicious with our questions, and we will as a panel strive to only ask questions of clarification of you. So over to you. You're very welcome to summarise key points, or if you're happy with the written material, we can proceed straight to questions, but that's over to you.
Good morning, panel. My name is Selwyn, councillor for Kaikoura. Thank you. We have lodged all of our evidence and legal submissions. Very happy to take questions on the legal submissions if you want to start with that, and then hand you over to our witnesses who are probably of more interest to you.
All right, thank you very much for that. It's a very efficient way of operating, which we appreciate. So we'll start with the legal submissions. If we have questions on that, Andrew, starting at your end of the table, any questions for the legal submissions?
No, I have no questions on the legal submission.
I have none either.
I like that one.
Thank you, sir.
Thank you, Ms. Semple. Just in terms of the your submissions that the PDP does not give effect to the NPS urban development. I'll call it NPSUD in the future.
Yes.
Yeah, just to recap, the PDP has three main objectives under the strategic directions chapter, which deal with urban growth and development. And then it has a separate set of policies. And I think your submission is to ask us to transfer all of those provisions into the strategic directions. In terms of the legal position on the NPS, I was just testing with you, is it not good enough to have three key objectives in the strategic directions, relying upon policies in a separate chapter? Does the NPS actually go as direct as to say that they should all be in the strategic directions chapter?
Well, I have to say I don't know. I don't know the answer to that, and I don't think anyone does yet, definitively. But if one looks at how the planning standards have been prepared, and also the way in which the NPS works, I think what you do is you end up with a collection of requirements. And when I put all of those together, what I say is, it seems to me that the planning standards direct you to having a chapter on, or to having a strategic directions chapter. They direct you to having urban growth and form within that chapter. And then the NPS tells you that you need to deal with certain matters that must, as a result of being in the NPS, be matters of strategic direction and importance for your district. So to me, when you add them together in the matrix, you end up saying that those important urban growth matters must come into that strategic directions chapter in order to give effect to both the NPSUD and the national planning standards.
So they must all be in the strategic directions in your submission. Okay, thank you.
Fine with me, thank you.
Thank you.
No, I'm fine, thank you very much.
I just have one question. It's more from a practical perspective, and you're happy to pass this to your planner if you wish to. But if we were to accept the submission that you've made, and we moved all of the provisions, the urban growth objectives and policies into the strategic directions chapter, that might only leave urban growth with rules and nothing else. And I'm just wondering how sensible or practical that is, or user-friendly that is.
Well, I wonder, I've thought about that, and I wonder whether, because there are not a lot of rules in that urban growth chapter yet, as yet, I think only one or two, and they could easily go into the residential chapter or into the rural chapter if need be. So I don't think that on a practical basis that would prevent Kangarora's submission from being given effect to. I'm also happy for Mr. Roberts to.
Yeah, if I can add to that, as part of Kangarora's submission, we've also asked for the future urban growth overlay to be transferred into a future urban zone, and those rules could go into that zone in our view.
All right, thanks very much for that. We can proceed to your first witness.
Thank you. So Mr. Liggett is here. Again, his evidence has been pre-circulated. Do you want to provide a summary? Are you happy just to answer questions?
Yeah, just happy to answer questions. I guess the purpose of this statement at this point in the process is simply to provide an overview about what we are, who we are, and why we're here, and why you'll see a lot of us during the course of the process you're about to embark on. So this is more background information. As we get through into some of the more substantive topics, we will present much wider evidence at that point in time.
All right, now thank you very much for that. We'll see if we have questions for you. We'll start at the other end of the table this time. Yvette, do you have any questions?
Fine, thank you.
I've really just got one question. KO, as we now know, Kambora, as we now know, it is a relatively new entity. And you operate under the Urban Development Act. How has that changed the way a public housing provider looks at the entire provision of urban development? Obviously, the Urban Development Act is set up to structurally provide you. Do you have any comments on what is said, or what is different now in terms of Kangarora's brief than it was previously?
Yeah, so the brief, in terms of the Urban Development Act, that's basically a collection of tools put into one place. 90% of those tools have always existed to the predecessor organisations that have come together. So it's simply just putting them all in one place. There are two additional tools that if a specified development project is advanced, we would get that we didn't otherwise have, which is a consenting function under the Resource Management Act, and also the ability to take rates in that geography. Those powers didn't exist. Everything else that's in the Act always did exist in one form or another. In terms of the mandate that we have, that comes out of the Kaingora Homes and Communities Act 2019. It is, and kind of touched on in the evidence, it's much wider than what the Housing Corporation Act had, for example. That was simply to provide houses for tenants. In terms of our mandate now, it has shifted twofold. One, we've got that function, but we've also got the urban development function as a delivery agency on behalf of the Crown. So we have Ministry of Housing and Urban Development set the policy settings for government. Our organisation is tasked with the delivery of that.
And just leading on from that, because it's a relatively new set of provisions, if you like, how is it working in practice in terms of the consenting framework?
Yeah.
Has it been used in terms of KO being able to provide the consenting function?
Yeah, so in terms of the Urban Development Act, that's got quite a prescriptive process that needs to be followed before those full suite of powers are available. There hasn't yet been a project reach that point. It will take about 12 to 18 months because it actually has to go right through to ministerial sign-off and order in council. We estimate it's about 12 to 18 months for that process to be completed, and at the moment there is not one project that has reached that milestone. So the consenting function has yet to be deployed at this stage.
Yeah,
Thank you. My question is around high development priority areas, of which we have the Christchurch, Greater Christchurch Urban Development Area. Then our district plan, which is one plan, also has areas outside the Greater Christchurch area with regards to development. Can you please explain to me if there are any differences between those two characteristics in our district plan?
In terms of characteristics of the district plan, I'd have to defer to Nick, our planner, because he's looked at it from a planning perspective. Yeah, it's best that he answer the planning questions rather than myself.
Yeah, that's fine. So Mr. Roberts, when we come to you, if you could just bear that question in mind.
I'm fine.
Just got to find it now. I want to talk about the specifics of SDDI01 at paragraph 3.4.1. You talk about wanting to delete the words individual communities for planned urban and non-urban form. Do you not think that if we were to accept planned urban and non-urban form, that the focus would still be on urban form? And therefore the objective would be narrowed.
Could I ask Mr. Roberts to answer that as a planning interpretation question? I wonder if that would be.
Yeah, that's fine.
Is that all right?
Yep.
Yeah, look, happy to go between if that makes it easier for commissioners rather than.
We can answer that particular question now if you like.
Yep.
Yep.
So the key phrase is planned urban and non-urban form, in my view. That means that the policy objective is forward-looking in accordance with the MPSUD, which recognises that the amenity of urban environments will change over time. So that's the key point we're trying to make, is that the current wording as notified, which reflects character, can be interpreted to mean just the current character. And in our view, or in my view, it should reflect the planned urban form as a forward-looking document.
So I think the question I asked was, do you think that using your wording would narrow the objective?
No, we'll broaden it in my view.
Okay, so leading to your second point, the objective does not use the word existing, as you've said yourself in the section 42A reports there. Do you not think that the reader will inherently know that the character of a place, like everything else, will evolve and change over time and will not remain existing as if it's stuck in time?
Based on my experience, plans that talk about the character of individual communities and objectives and policies are often interpreted to mean existing character. And I think the way in which the EPSUD is directed councils now, it's to change that approach and to look forward. So I think the wording as proposed, as notified, is quite limited in its interpretation. And what I'm trying to do is suggest some wording that enables council to look forward. So I also note in other objectives and policies in the plan, they talk about anticipated character in future in urban zones, for example, and that's more forward-looking. But the current wording of this objective can be interpreted as just meaning existing. That's my view.
And I suppose everybody has their own interpretation.
Exactly, and that's the problem in terms of leaving the wording like this, in my view, and that it could be interpreted, in my view, probably would be interpreted by many people and to mean that it would just existing character.
Thank you.
No questions.
Okay. Yeah, I got a question from Mr. Liggett. Yeah. So Mr. Liggett, just coming back to your evidence, paragraph 5.2. And you say there in the very top of that paragraph, the PDP has the potential to reduce regulatory constraints and increase housing supply. And when I read that, I thought in my mind, I imagine that you also, when you wrote that, thought, but that needs to be consistent with the Canterbury regional policy statement, particularly change 1 to that statement. So there's a caveat around that.
Yes.
Yeah. Okay. Thank you. Commissioner Ray has a follow-up question from Mr. Liggett.
Well, actually, it was for Mr. Roberts. That I was going to ask you later, but it's a direct follow-on from the question Commissioner Solomon asked you about that, the word existing and planned. And you said that the current objective is too constrained because it only deals with existing. But the wording you suggested, and I'm not sure whether this question was asked to you, the wording you've suggested is just using the word planned. So I'm just not sure how we deal with the existing character if we're only going to have the word planned.
Well, just to be clear, the current wording doesn't mention existing. It just says, takes into account the character of individual communities. Planned urban and non-urban form, in my view, leaves the door open for council to reflect that in its zoning provisions. So it can look forward in terms of some zones, and it can also have other zones that have less change to reflect amenity value change for various reasons. So the wording, what I'm suggesting is that the wording just needs to be open to enable a proper interpretation of that high level strategic objective to be interpreted down into the zoning provisions that then can reflect change in amenity values as per the environmental issues of each zone.
I fully understand that. I'm just wondering whether the word existing should be retained somewhere. In other words, takes into account the existing and planned urban. Otherwise, how would we take account of the current character? I think the other commissioners are remembering that they have a similar question. Yeah. Understand your point about future. How do we deal with the existing character under that policy? Is there a compromise possible?
There could be a different way. I mean, it's never perfect the way anything's worded, really. So it could just say anticipated character of individual communities, which, because that's also reflected, as I've mentioned, in other objectives and policies of the proposed plan, and that anticipated character could be interpreted in some zones to mean little change at all, but in other zones, a lot of change. So, yeah, thank you.
I'm just following on from that, just mindful of the character of individual communities, because the character it currently has now is important to be looking at as well, I would have thought, along with what's into the future. So could that actually, whatever comes out of the wording, encompass what is now as what is to be in the future? If you understand what I mean. If you're saying what's currently there is just looking backwards.
What I'm trying to say is that planned urban and non-urban form can vary between zones, and in some zones it can mean that the change might be quite small for various heritage reasons, for example, but in other zones it might be quite significant because it's close to a town centre. So I think the wording that I've suggested covers those issues you've mentioned without having to put in there existing and planned, if I am answering your question correctly.
Okay.
Yep.
So now, I think we are now, we have a question. Yeah.
3.5, you're altering the wording here. You're talking about urban growth is located in or around, and you've struck out that adjoining existing township in a compact and sustainable form that aligns with its anticipated role in the township network. Do you not think that if we take out adjoining, we will end up with gaps in development? We could end up with ribbon development? Is that what's your anticipation?
Well, so just to be clear, the plan as notified has the word around in it. And the recommendation of the reporting planner is to replace that with adjoining. In my view, as I've set out in my evidence, land doesn't have to directly adjoin an urban environment to result in a good outcome in terms of the requirements of the NPSUD, provided it's within walking distance and it's connected to infrastructure, then a good urban form can still result. You may have, for various reasons, some sections between or some land between a proposed development area that is just not going to be developed for quite a while yet. That development area might be only 300-400 metres from the township. And I don't see any reason from a supply issue to hold that back if it can be connected to infrastructure. It's within walking distance of the township and can be serviced by some form of public transport.
Okay, thank you.
Yep.
So Ms. Hempel, we've been jumping around a little bit. Apologies for that. We'll
It's
try
all
and
right.
we'll try and stay a little bit more focused in the future. But can you I think we'll hand over to Mr. Roberts now. Your next witness. And
Did
is there,
you want to say anything else before we?
I think just from Kaingaroa's perspective, in terms of the planned urban character, we're drawing that in terms of the submissions we're putting forward directly from the NPS, which is talking about that the planning decisions, when those are made, should be reflective of the planned urban form rather than the amenity values of the past. And that policy 6 is our read of that is quite prescriptive and directive about what the decision should consider. Hence, it's not the only jurisdiction where we're suggesting character is tied to the planned character going forward. And as described in the plan, as Nick has highlighted, that can include elements of existing character, but also take into account the forward-looking character that is described by the plan itself. So it's a consideration of the plan rather than what you see on the street when you're actually walking down the street is the measure of your assessment.
Thank you.
Thank you. I'll just quickly summarise. I've got 4 points in my statement. The first is on the that issue we've spoken about, which is relating to objective SDDI01, and the wording I've suggested to read takes into account the planned urban and non-urban. As I've suggested, in my view, that policy, that objective wording is forward-looking, does enable different interpretations to be flowed through to the zoning provisions. And the point I make is that, in my evidence, is that the planned urban and non-urban form for each zone can also be expressed in the objectives and policies of each zone itself. But it recognises the planned future form may vary between the individual zones in response to local issues, including anticipated amenity values. The second point I make is in terms of a compact and sustainable township network. That's objective SDUFD01, and that's dealing with the Commissioner's question regarding replacement of the word around with adjoining as suggested by the reporting planner. So in my opinion, there are outcomes that can result if land does not directly adjoin a town, and the principle of consolidation applies irrespective of the proposed wording change. In terms of the other components of that objective. So there are issues as I've identified, or matters I've identified in my evidence, which in my view appropriately address that point. The third point I want to make is in relation to urban growth and development, is SDUFD02. And this is the wording that I've suggested that that objective be amended to say there is at all times at least sufficient feasible development capacity. In my view, that better aligns with policy 2 of the NPSUD, which specifies that tier 1 to 3 councils at all times provide at least sufficient development capacity. So I think that is a logical change to that objective. And the last point I make is in relation to moving the urban growth objectives to the strategic directions chapter. In my view, the planning standards are quite directive in terms of outlining that that any objectives and policies relating to key strategic or significant resource management matters for the district relating to any topic, not just urban form, must be located within the strategic directions chapter. And in my view, that those objectives and policies are clearly that. And what I'm trying to say is that it's better, in my view, to say it once and say it right in a plan, not have a high level, very broad section and then dealing with that matter, and then it dealt with again in another section and then dealt with again in the zoning provisions. In my view, there's the objective and policy hierarchy that's been promoted in this plan, which quite rightly sets the strategic objectives at the top of the hierarchy, should be used properly with very explicit directional objectives and policies in that section for a much easier to interpret and directive planning outcome. So those are the key points I want to make.
Great, thank you very much for that concise summary. See if we have questions, any further questions for you. And Andrew will start at your end of the table first.
Yeah, thank you, Mr. Roberts. I did have a question concerning the character of individual communities in planned urban form, but I think that's been answered. I won't go back to that. I do have another question. So paragraph 7.5, you referred to RPS objective 6.2.2 when you referred in support of statement, and you looked at the word on the periphery, and you took some guidance from the RPS and some support for your proposed change around where urban growth and development might occur. So my question, did you also look at the policy 631 and map A as well on the RPS, which are appear to be quite directive around where development can occur?
Yes, I did.
Right. And did you see any conflict at all between the objective, which talks sort of generally around in the periphery, versus those the policy and the map A, which were quite specific about where it should occur, as opposed to generally around?
That map, from my recollection, that is directive in terms of showing where it should occur. But in my view, parts of those areas can come forward first. They don't need to be directly adjoining. It doesn't need to be staged in a way that only that land is released in a way that only those parts adjoining the urban environment are developed first. Some setback further could be developed first, provided they still result in a good urban outcome. That's the point I'm trying to make there, that the policy, in my view, is too limiting.
Okay. And 9.10, again, this is around strategic objectives having primacy, and where should the urban growth provisions be, I think. You've made the comment that demoting urban growth objectives and policies to the general district-wide matters was deliberately intended to give it secondary status and inconsistent. Do you think it could simply be a style choice around higher level directions in one document, in one chapter, and the level of detail that gives effect to or implements those directions in another chapter where the detail is? Could it simply just be that, rather than deliberately giving it a secondary status?
I mean, obviously, there are different preferences of styles of plans, but I think the urban growth matters that are covered in that chapter are very strategic and are very important to have in that higher level objective policy direction, given the hierarchy of this plan. So, reading those objectives, UG 01, 02, and 03, which deal with how growth is to be provided and where, the consolidation compact urban form, and that there's sufficient feasible housing and sufficient business development capacity. Those are all matters that, in my view, are they're basically at the primacy of what's trying to be achieved here from an urban reform perspective, and should sit in that strategic directives chapter. Some elements, yes, could potentially roll into other zones, and I think we've spoken earlier about if you had a future urban zone, putting the rules in there, you could also have some objectives and policies that dealt in a finer grain with that. But having, in my view, the majority of these objectives and policies in that strategic chapter is very important in terms of having a very legible and directional plan.
Okay, thank you.
Okay, it's just a follow-up question to what the chair asked earlier about the urban growth chapter, if it was to be decimated, if you like, by. I think I understood your submission to be that all of the objectives, except objective 1 would be removed. That's how I read the 42A report, so that objective 1 would remain in the urban growth chapter, and some rules would be transferred to a future, another chapter. But from a planning point of view, how would the plan look from an integrity point of view if there was a very, very constrained, limited urban growth chapter, or have you not turned your mind to that? Are you more concerned with the outcome in the strategic directions chapter?
I specifically haven't turned my mind to how the plan could be redrafted to address that, but I'm simply making the point that these issues, in my view, should sit at the top of the hierarchy. Yep. Yep.
My question is understanding the difference between, we have one plan, we have urban development within the Greater Christchurch urban area, which is under the National Policy Statement for Urban Development, which is separate from our other communities outside. And I'll just say Rolleston versus Darfield or Leaston. How do you actually interpret through our plan, because we only have one objective at the top, do you see that we would separate that out, those two systems out in your new urban form?
No, I'm sorry, I can't. I don't
So,
understand
sorry,
the question.
my question was clearer before because I was asking it in regards to Mr. Leggett. I want to understand with regards to the character of our communities.
Yes.
We have different characteristics because we also have the Greater Christchurch Urban Development Area, which is under the National Policy Statement for Urban Development. Then we have legislation that actually covers our communities or areas outside of that area. Having one plan, shouldn't we just have a clear objective with regards to mentioning the character of our communities?
Yes, you should, but in my view, that objective should reflect a forward-thinking approach. Does that answer it? I think that the objective framework needs to cover those communities, but they need to, that objective framework needs to be forward-thinking and enable change in those communities as appropriate to reflect the direction of the NPSUD, while also enabling some areas to be to change very little because they may have particular important characteristics such as heritage that need to be valued and cherished. So that's my point, is that I think the wording of the objective that I've suggested that does cover those issues.
Too narrow.
Yeah. Lindsay?
At the risk of going over some of the previous ground, I guess I'm a little bit bothered about this term non-urban to be inserted in there. I've not seen it anywhere else. What is it define? Is it supposed to also include existing natural values and so forth in that non-urban form? Is there a better way of getting to where you think it needs to be without needing to use possibly only my opinion is a country term? It doesn't really have its genesis anywhere else.
I've been reflecting on that too. I agree that the use of the phrase non-urban is quite unusual in a plan. And just really reflecting on this over the weekend, actually, another way to do this is to change the wording to say takes into account the anticipated character of individual communities. And that reflects better the wording in the strategic, in the urban growth section. So objective UG 012, for example, says maintains and enhances the amenity days and character anticipated within each residential and business area. So placing that word anticipated into that objective still leaves it open to look forward, but also to say in some cases that the current is okay, that it's anticipated that there may be little change in some areas of our community for various heritage reasons, for example. So yes, I'm open to different suggestions, and I think one way of doing that could be just to put the word anticipated before character into that objective.
Right, then my second question for you is around this, around or adjoin or in the periphery.
Yep.
I guess the beauty of having a join is it's very directive. You actually know what you're talking about. Around is a little bit more fuzzy in terms of direction. It could be that there is a site which is close you know, a kilometre down the road, and you could actually say, oh, it's around the periphery of the township. Others will say, well, it's not around because you can't walk anywhere. Is that something which needs to be more closely defined at policy level in terms of adjoin or around? I think with the strategic directions, you actually want to provide that direction. And the word adjoin is very definite, it's very precise, it's very known, whereas the word around doesn't provide that level of certainty. Another option is perhaps in the periphery, which is a term which is used elsewhere, particularly the CRPS. Just what would be your comment about providing a plan user with a bit of direction, or a decision maker on a consent application with a little bit more direction around that?
Yeah, in my view, the word around does work because that, if you read SDU, FD, 01, 02 and 03 together, all of those objectives and policies, objectives together require different things. So 01 requires urban growth is located only in or around existing townships and in a compact and sustainable form. So there's two legs to that objective. 02 requires that there's sufficient development capacity. And 03 requires well integration with the urban growth and development to be well integrated with efficient provision of and funding of infrastructure. So if you read those things together, in my view, the word around will ensure when you read everything else that you have a compact form still, but that you don't actually have to touch the urban area to achieve that, and that you can still achieve the objective and direction of the NPSUD through reading that as a total package of objectives. Yeah, okay. There are examples for. There is an example I found in the plan in Prebbleton. There's an urban growth overlay area that's not adjoining the township, as set out in the proposed plan. And that's an example where councils obviously thought, well, that area can go ahead because it's close enough and within walking distance of the township itself. I'm not sure of the background to that area. I just saw it on the planning maps, but there is an example in the plan where there is an urban growth area that does not directly adjoin the urban area. And that must be an example of where councils felt it's appropriate in terms of being able to link that area to the existing urban area in a certain way.
Okay, well, we may hear a little bit about that. Obviously, this whole issue you're talking about is very much ingrained with the urban growth provisions, which we're looking at in 3 weeks' time as well. But these are the very apex level objectives that we're talking about here. Which leads me to my next question about the whole structure of the plan with the urban growth objectives and policies being pulled across to this very high level strategic goal setting. These are the outcomes which a district wants to achieve level. And the level of specificity that there is in the urban growth chapter about how that will be delivered is quite different to the level of specificity that there is in the other strategic level objectives. Do you have any comment on that?
Well, I mean, in my view, as I answered earlier, the majority of the urban growth chapter deals with those strategic issues. There could be parts that are pulled out into a more fine-grained zoning platform, such as future urban zone or some similar zoning framework. But I think the majority of the issues, particularly in the objectives, should be pulled over. The policies, yes, are more detailed, but a lot of those issues deal with zone-specific matters. So they could potentially be pulled into the zones themselves. But I think my reading of the strategic objectives at the moment is that they are too high level. They don't give enough direction. They're at the top of the hierarchy, and that the plan would greatly benefit from pulling at least these objectives in the urban growth section through to that higher hierarchy to make sure that the outcomes are well understood and specific in the district. So there is, as I mentioned earlier in an answer, I haven't put my mind to how it could be cut and diced, but definitely a lot of the content in this, in the growth section should, in my view, be put at the top of the hierarchy. It's very helpful.
Yeah, okay, I understand that. I'm thinking more structurally how the plan is going to operate here. You haven't provided us with an alternative relief about what the urban growth strategic directions will actually be, other than to say transfer basically that whole chapter across. And some of the matters, and I guess we'll deal with this in a few weeks as well, might be at that level where they're really location based, if you like. They're a guidance to a location or a guidance to a form of development, as opposed to an outcome. So
yeah,
I guess it would be interesting to actually see how these revised urban growth objectives at the strategic level would actually look like, and whether they are actually strategic or whether they're much more focused about the implementation.
Yep.
So
okay. We can look at that.
That's potentially my observation at the moment. I'm a little bit concerned about what they actually look like, and then what the more detailed things actually look like and what they will deal with.
Yep.
So
that's a fair point. In my experience, the location-based objectives and policies which deal with each zone can be put in the zones themselves, and that's commonly adopted throughout New Zealand. But I take your point that we should probably turn our minds to how that could potentially be cut and diced, and maybe come back to the next hearing with suggested rewording of that.
all right, I have no further questions. Thank you.
Kia ora. No, I have no further questions. Thank you.
Just one question and then just a follow-up in terms of that last discussion. Just turning to your paras 7.5 and 7.7.
Sorry, 7.5.
And 7.7, sorry. So it's back to that issue of around or adjoining or some other word. And again, a similar question to what I asked before. And you refer to some provisions in the RPS. Did you, when drafting your evidence and pulling your thoughts together, consider the RPS objective 6213, which is it's a very directive objective. It starts with the word avoids, and it says avoids urban development outside of existing urban areas or greenfield priority areas. And how would that impact on what wording we should use? We all know what avoids means now, post King Salmon.
Yes, absolutely.
Yeah.
Yeah, I've looked at that. I mean, in my view, greenfield priority areas, avoids urban development outside existing urban areas or greenfield priority. Yeah, so greenfield priority areas are obviously those areas that you've identified in the urban growth overlay.
And map A of the RPS.
Yeah, and map, yeah, but also, but in terms of how that's been transferred down to a district level, it's the urban growth overlay areas.
Yeah.
And what I'm trying to say is that the staging of those areas doesn't need to be rolled out in a way in which the live zoning directly adjoins the existing urban area, which if the word adjoin is put in there could be an interpretation. And also that there is an example in the current proposed plan where one of those areas does not adjoin an existing urban area. So I think but putting the word adjoin in there does create some conflict with the way in which the plan is being set at the moment. Okay. And I think around is a better phrase to cover that.
Okay.
Yeah, and that objective you pointed out to me still won't be compromised.
Yeah, you had a discussion with Commissioner Dash and a few others about what the strategic directions chapter might look like if we were minded to grant and follow apart the relief that Kainga Ora seeks. And you've offered to give that some further thought. I think it would be very helpful if you did do that and came back to us with a set of track change provisions that puts into the strategic directions and the key objectives from the urban growth chapter that you've obviously been thinking about either before or during this part of the hearing. But in terms of timing, we'd appreciate that being done relatively quickly so that when the officers report back to us within 2 weeks of the end of this week, that they can bear in mind that information you provided. So if you could do that, if not by the end of this week, then by say the middle of next week, would that?
Yes.
Yep, and that can just be provided to Mr. Love over there. You can just email that directly to him.
No problem.
Okay. All right, well, thank you very much for coming in this morning. I'd like to thank you for preparing the written material that you did and submitting it. That's been very helpful. And as you can see from our questioning, we have read it. So we do appreciate the fact that you didn't then try to read it out to us, which some submitters always try to do because they don't think we've read everything, but we have. And so that was a very good, in terms of process, it was a good submission to start with. You've set the scene. So thank you very much for that. Enjoy the rest of your day.
Thank you for your time.
Thank you.
New Zealand Transport Authority, Agency, sorry. So good morning and welcome.
Good morning.
Do you want to introduce yourselves to us, please?
So my name's Stuart Fletcher. I'm a principal planner employed with the Transport Agency. On my left is Selena Lee. Now Selena works with Waka Kotahi and she is our connection to the Greater Christchurch Partnership. So she attends the various meetings and so on. And so when I was preparing my evidence, I was talking to Selena quite a lot, and I thought there is benefit for the panel to have Selena here as well, in case there's any really hard questions, I can pass them on to her. So in terms of the evidence, you've obviously got that and you've read that. I thought I'd just sort of paint a little bit of a picture, less about this evidence, but more about we'll be attending a range of hearings and so on. And so for Waka Kotahi, it is an interesting situation for us in that our roles are to provide state highways, to maintain and improve them. We're involved in providing additional, I guess, enhancing the state highway network and so on. So you sort of see Waka Kotahi as you might say, a road builder and maintaining it. But we've also got the interest in terms of people doing things that affect state highways. Traditional issue is reverse sensitivity. But what sort of, I guess, is almost an increasing area is the impacts of state highways. For example, we're working through to signalise an intersection out in West Melton, and by signalising that intersection, are you increasing creating an area to develop further? In that West Melton example, you're encouraging pedestrian connections, cyclists and so on. So does that mean you're going to enable a larger urban area on the opposite side of the state highway? So there, you start to see those factors developing as well. We also start to see issues like for Waka Kotahi to think about emissions, and that comes down to planning quite a lot as well, in that if you enhance your area of state highway, are you enabling larger urban areas, which is then increasing the potential for emissions to be generated. So while everybody thinks of Waka Kotahi as building state highways, what can happen has wider implications, hence why we'll be around for a variety of hearings looking at a variety of topics. Yes, beyond that, I'm happy to assist in answering any questions.
Thank you very much for that. We'll start at this end of the day.
Just one question in relation to your paragraph 5.6 about objective 1. You say, suggested that objective 1 is confusing as to its purpose. Is it to ensure the needs of the community are fulfilled, or is it to protect the operation of important infrastructure? Further consideration of this issue is recommended. In terms of the structure of that objective, what would resolve your uncertainty about that?
Well, it's really looking at those three objectives, in that when you read objective 1, it reads the important infrastructure needs of the community are fulfilled. So, so you're looking at the infrastructural needs for the community. So it's, whereas with the second and third, it's the development, upgrade, maintenance and operation of all important infrastructure is enabled, and then natural hazards, the risk from natural hazards and so on, including the effects of climate change to people, property and important infrastructure is not increased. So I see those second two objectives using the term important infrastructure in a different manner from the first one. The first one is looking at the needs of the community and their important infrastructure needs, whereas we have this definition for important infrastructure and we're using it in a different way. And so I thought about the wording of, you know, you could just remove the word important and say the infrastructural needs of the community. That's sort of where I read that first part. But then you finish at the end with, and their operation is protected. So are we talking about the needs of the community and the operation of the community is protected, or are we talking about the important infrastructure? That's where I sort of start seeing that element of confusion. Such that I was hoping I could just suggest one little, tweak, and you're right to go.
So you think it actually does two things, that first objective?
Well,
recognising that community needs infrastructure, and when you do have infrastructure, you've got to protect what's there for, and protect its operation, maintenance, etc. as well.
You certainly could take it that way. It seems like there's two parts to it, but it's just that opening language, the important infrastructure needs of the community. It's less about the infrastructure and more about the needs of the community. So I agree, it would be good to think about the protection of infrastructure. But yes, maybe you adjust the wording so it's reflecting both the needs of the community and the protection of the infrastructure.
Okay, and possible solution is to have that about community needs for all infrastructure as opposed to important infrastructure, which is a defined term in the plan. Is that a possibility?
Yes, yes, but just as I say, think about the finishing part as well of that objective, where it says, and their operation is protected, just because of that community element in there as well.
Thank you. A few other submitters have got some comments and alternative wording as well on that objective as well, I noticed. Thank you.
Yes.
Just one clarification, and I guess it's just touched by a colleague. Precedent setting, if we were to put in and recognise important infrastructure, where do we then sit with other submitters that are looking at the rural aspect of importance within their community?
So is there a specific paragraph?
Yes, there is. You've mentioned, I've got to find it, it's the sustainable agricultural submission, wanting recognition of rural activities. You said you didn't agree, but you didn't disagree. I'm just wondering whether if we include in this high level objective mentioning about infrastructure, then would it not open the door for us to have to accept other submissions looking at their specific issues in that objective? And I'm just using the sustainable agricultural submission as an example. And you've got that on, sorry.
It's not really a question for Mr. Fletcher in terms of how we might consider others.
It's just that he's mentioned, I just wanted an explanation as to mentioning the precedent. Did he consider it to be a precedent?
So there's,
oh, sorry, I can't find it.
so paragraph
4.7,
yes,
sorry, 4.7, yes.
So at paragraph 4.4, I discussed the SDIR 01, which talks about the important infrastructure needs of the community are fulfilled and their operation is protected, which is the existing objective there. And we are in support of that. And then at 4.7, what I am essentially highlighting there is that if we're not opposed to that point from Ellesmere Sustainable Agriculture, and instead, and we're not seeking the inclusion of the term infrastructure and so on as part of that, all I'm highlighting is that you just got to be a little bit careful with your wording, because if you look at rural productive activities, how far can you take that? Does that mean plants that are processing products or rural products and so on? So does that enable some, say, factory, for example, in an area? And what are the impacts for state highways? Is there the need for intersection upgrades and all those kinds of things? So saying we're not opposed to the inclusion of that, but you've just got to be a little bit careful with your wording and the expectations it could create.
Thanks for that clearer explanation.
Just one question, Mr. Fletcher. Thank you. Just on the higher density living, the high density living part of your evidence, 6.6 through to 6.9. Just wanted some clarification, please. On paragraph 6.8, you say that Dr. Kitaki has raised a question about whether the objectives for urban formal development need to be more encouraging or explicit in promoting high density living. am I to take it that that's your position, is that they should do that, that Whakaputahi supports high density living, and is that what you're saying there?
Yes.
That's a question, but I presume it's a desire for you to see more provision in the plan.
That is our desire, and to some degree, this also stems a bit from the national policy statement for urban development, and that there seems a little bit of a mindset that in order to provide that, you may need more land, whereas the way you could achieve it is to have higher density living in some areas. And that, coming back to my opening, if you have your higher density areas centrally located, then you've already got your better connections, say to your commercial areas, your cycling, your walking opportunities, but importantly, things like bus connections as well. So, yeah, I guess I'm suggesting that to encourage that higher density within existing areas is positive.
Thank you. And then in paragraph 6.9, you sort of, I guess, take issue with the reporting officer that objective 1 doesn't really go far enough. You say that you're really asking us to consider whether improvements could be made to objective 1. And I guess my question is, have you got any particular relief you could put to us?
That would have been very useful of me to do, but no, I don't have any specific wording for that. Sorry.
Right, Mr. Fletcher, thank you very much for coming in and for bringing your colleague with you. Did you wish to add anything at all?
Yeah, on the last point that Mr. Fletcher has submitted, so is really we want to make the best use of our existing network. So the higher density residential area will enable that. So that is just it. Looking into the future, we want to make it open to possibilities.
Great.
Thank you.
All right. All right. Thanks very much.
Thank you.
We're running a little bit ahead of schedule. Mr. Ensor. All right, so we'll take an early morning tea and we'll resume at 10:45. Get underway. Good morning, Mr. Ensor, and welcome. Thank you for coming in this morning.
Kia ora.
Thank you for providing your evidence. We have read that, so you don't need to read that out loud to us. You're very welcome, though, to, if you wish to summarise any key points, or if it's your preference, we can just go straight to questions, but it's over to you.
I might just touch briefly on key points. There's really sort of two main issues that I've highlighted here. And the first one is in relation to an amendment proposed by Christchurch International Airport to the objective of important infrastructure objective. And as I've pointed out in my evidence, the issue is not so much with the objective, but the flow-on effects through into the policies and rule framework to come. And the main issue is, I guess, the scope of a potential bird strike management area or buffer, and the sort of consistency or otherwise of what's proposed with what's in the Christchurch District Plan, and the challenges that might pose for a number of activities, but including my client, Copenhagen, in relation to quarrying activities. Is acknowledged that the objective itself is not an issue and in itself, but there is, I guess, a potential process or question that or issue that I've raised about how this hearing deals with various topics as they go, whether there's decisions made in an interim. Sorry, I didn't attend earlier. You may have already addressed some of these matters, but if interim decisions are to be made, I have requested or suggested there that maybe the matters that are being addressed here from a strategic directions perspective sort of be held over until some of the key issues that Copenhagen has raised, for example, in their submission, be sort of addressed at the same time. So that's probably relatively straightforward. And the second point also relatively straightforward. I requested change to the objective for urban growth and development by the Gulf Property Group to change the words sufficient to as a minimum ample. And I guess the only point I have really raised there is that maintaining some consistency of language through the MPS on urban development, in my view, seems like a more sensible approach, less potential for interpretation challenges down the track. And so that's what my view is and what I've suggested. So really that's all I wanted to point out, and happy to take questions.
Great, thank you very much for that. And Andrew, will start at your end of the table. Any questions from Mr. Ensor?
I just do have one question. I'll just find it. I found it interesting your comment in paragraph 23, requiring more development capacity than is required is potential to create greater conflict between competing land uses for limited gain. I was wondering whether you wanted to elaborate on that. So do you mean in terms of reverse sensitivity, or is difficulty getting land for other activities if it's already identified for urban development?
I think that the point I was raising there was the difference in terms of ample, as a minimum ample and sufficient. So the sufficient means enough for, so covering off the needs as identified, whereas as a minimum ample could potentially go beyond that, and having land that is earmarked for residential development may mean that there's an opportunity cost that other land uses couldn't develop in and around it. That land, because of this earmarked potential future, that may not necessarily be required. It's if it was more than sufficient, if that land was more than sufficient, that answers your question. Yeah.
Thank you.
Yes, just one. In your paragraph 9, you talk about susceptible to sterilisation by competing land uses. Can you just explain to me what you mean by sterilisation?
Sorry, was it paragraph
9.
9? My paragraph 9, sorry, has
Sorry, it's in your markup version. Markup.
oh, sorry, that you mean the submission.
Yes.
Sorry. I don't, my computer's had a little meltdown. Sorry, if you could just repeat the question and I'll just answer it from you.
In paragraph 9, it talks about resources, therefore, susceptible to sterilisation by competing land uses.
Sure.
What is meant by sterilisation?
I guess the aggregate resource, it exists where it lies, and you're not able to undertake the activity elsewhere. You can only undertake quarrying where the aggregate resource exists. And if a sensitive land use were to establish near an area of resource, for example, it may mean that the resource can't be accessed due to, for example, effects on amenity on that sensitive land use. So the term sterilisation it really refers to the ability not to be able to use the land for quarrying in this instance.
So wouldn't that have been a simpler way to put it?
Possibly.
I have no further questions. Thank you.
Thank you.
All right, thank you, Ms. Well, no further questions from me either, but I just for the words used in the superior instruments, and that's something that will be in our mind throughout. So thank you for drawing our attention to that.
Exactly.
Thank you very much for coming in.
Thank you.
Thank you.
And the next submitter on my list is Foodstuffs South Island Limited and Foodstuffs South Island Properties Limited. And good morning and welcome. And if you'd like to introduce yourselves to us, that'd be great. Thanks. Great. And I'm not sure how long you've been sitting in the back row there, but we've thank you very much for pre-circulating your legal submissions, which we've read. You're welcome to highlight any key points from that for us, or if you prefer, we can just go straight to questions. It's over to you.
Okay. Oh yeah, that sounds better. So you'll hear a lot about the recent National Policy Statement on Urban Development throughout this proposed planned process and how it must be given effect to. And so for context, I just wanted to highlight a couple of things this morning for you all to consider. So the Cabinet paper supporting the MPS on urban development identified the urban market as dysfunctional, and the driver of this being an unresponsive planning system characterised by a reliance on restrictive land use regulation and the controlled release of land for urban purposes. The recommendations and decisions report for the MPS also stated, urban areas are dynamic and complex. They're continually changing in response to wider economic and social change. The current planning system can be slow to respond to these changing circumstances and opportunities, which can lead to a mismatch between what is enabled by planning and where development opportunity or demand exists. And this can lead to delays in supply or incentivize land banking. And the intent of the responsive planning provisions in the National Policy Statement on Urban Development is to enable the planning system to work responsively towards more competitive development markets, through development, including at scale. And the other context I wanted to just highlight this morning is the Environment Court has considered the previous Urban Development National Policy Statement and made this point. The statement is to open doors for and encourage the development of land for business and housing, and not to close them. So with this context in mind, the question I ask is the proposed Selwyn District Plan responsive? And it is submitted on behalf of Foodstuffs that as it currently is drafted, it is not. Why? Why do you ask? Foodstuffs have identified, and it's detailed obviously in the legal submissions and evidence that's provided, but for the purposes of highlighting this for you today, that there is demand for additional supermarket offerings, but there's inadequate provision for both the existing supermarkets already within Selwyn District and planned future supermarket activity. Supermarkets are only provided for in the town centre zone and not other commercial mixed-use centre zones or outside centres. And there's no suitable land for a large format supermarket within the existing town centres. So a Pack and Save, for example, is unlike your typical neighbourhood convenience store and is not suited to a main street town or a mall environment. And there is otherwise no provisions in the proposed plan to enable a supermarket, including through well-considered resource consent applications. It is submitted that supermarkets should be able to secure resource consents in catchments where there's a justified need for that essential service, provided it can be justified on its merits and adverse effects managed when considering the receiving environment. And so in my legal submissions, I've addressed in detail, and I just wish to highlight two of the particular provisions which require you all as commissioners to consider when you are doing a planning decision. And what you are now listening to is obviously considering as a planning decision. And that is objective 3, which requires the proposed district plan to be enabling of more business to be located in areas of urban environment in or near a centre zone, not just in a centre zone, or other area with many employment opportunities and where there is a high demand for housing, and to achieve a well-functioning urban environment by having or enabling, as a minimum, a variety of sites that are suitable for different business sectors in terms of location and site size, and supporting the competitive operation of land and development markers. So these concepts will be dealt with more extensively throughout the Selwyn District Plan process, and evidence will be presented in the relevant chapters. This hearing today is obviously the strategic directions, and the submission of Foodstuffs is that these directions should not unnecessarily restrict the plan's ability to respond to change or achieve responsiveness, which is what we're setting out, or what's been set out to achieve in the NPS on urban development. And so in conclusion, through this plan change process, the Selwyn District can and should, in our submission, step up and respond directly to the NPS on urban development. The changes sought by Foodstuffs will better assist the Council to give effect to the recent National Policy Statement and achieve the sustainable management purpose of the RMA. And Foodstuffs is happy to work constructively with the Selwyn District Council throughout the plan process to ensure adequate and appropriate provisions are achieved for business activities, particularly supermarkets. And Commissioner, did you want me to refer to the changes that we're seeking? Because you'll have seen in the legal submissions, we're generally supportive. Foodstuffs is generally supportive of what has been set out in the strategic directions, and particularly in terms of business growth and development. And there's only 3 minor word changes, I would say, small changes which just keep that flexibility in terms of allowing the decisions to be discussed at detail in subsequent chapters. So that would be my legal submission summary, and we're now available to answer questions.
All right, thank you very much for that. And Mark, we'll start at your end of the table.
Thank you. Just a clarification. When you're discussing a supermarket, are you meaning a standalone supermarket, or are you actually talking of a retail centre with a supermarket as an anchor tenant surrounded by other retail offerings? Because there's a difference in scale and size depending on which way you answer that.
Correct, Commissioner, and that's a very good question. We are talking about enabling standalone supermarkets outside of a centre and express provision for supermarkets within centres, whether that be coupled with retail or alternatively. The economic evidence that will be provided in subsequent hearings is that a supermarket outside of a centre as a standalone would not have adverse retail distribution effects on a centre, but we're not suggesting that it should also have retail if it's outside of that centre.
So to use your example of a pack and save as you were saying that the plan could enable a standalone pack and save to be developed outside of, say, Rolleston town centre, but not necessarily with an associated retail hub with it.
Correct, because as we will seek in further chapters, you would need to manage any particular adverse effects. So if you couldn't demonstrate that you weren't going to have retail distribution effects, then you wouldn't be able to locate outside of the centre. So we have evidence in terms of a pack and save, for example, in other situations, not causing retail distribution effects, but we are not intending to supply evidence to show that a pack and save coupled with other retail could also achieve the same, because we don't have that information with us. So.
Just to follow on, because the kind of questions I was looking at, but just to follow on. So in your submission, what you were saying is that it's restrictive in terms of not enabling the smaller businesses that might want to be able to come within to here because of the planning regulations that would be around that. Can you just clarify a bit for me on that?
So I think, so I'm obviously representing foodstuffs today and they're in the business of supermarkets. So the focus of the submission has been on supermarkets. Having a look at the plan provisions across Selwyn District now, if you were to look in the town centre zone here in Rolleston, it's a very defined zone and foodstuffs have assessed the land there and there's no site suitable to put a supermarket. Now, the town centre zone is the only place in the entire district plan which provides for supermarkets. Other than that, they are not provided for at all. There's restrictive objects and policies, which would mean that even a resource consenting process would be very difficult to achieve that. Yet we've got our clients saying that they have a demand and they want to provide a supermarket. If you look, for example, across the road at the I zone, a supermarket would be a non-complying activity there. There's other mixed use zones around Rolleston Centre. Supermarkets aren't provided for there. Outside that, in a residential environment, you know, where, say, the previous operative plan had provided for an element of non-residential activity, provided you could justify it with an assessment under the resource, through resource consent, there's a very restrictive objects and policies which don't allow that either. So the submission we're putting before you is probably not focused on smaller retail, but rather supermarkets as a retail activity. And that, you know, with the demand and the fast-paced growth of Selwyn, and this will be supported with evidence, economic evidence as we progress to chapters, there's this real, you know, there's these large catchments, there's a demand for this essential grocery offering, but we're very, very limited in the current provisions of where to put one. And one example, Ms. Parrish, do you want to talk to the fact that you have got a consent for a pack and save in the town centre here, but that it's not able to be achieved?
Okay. Council may be aware, well, I'm sure they are aware, that we do have a resource consent for a pack and save in Rolleston Town Centre. What that consent achieves is that the New World would be demolished and a pack and save would take over the entire site. More than likely the shops would be demolished and it would be a pack and save just there. Now that the ramifications of a pack and save is that a pack and save needs 2 hectares of land. It generates 30 to 40,000 traffic movements a week, which is the equivalent of probably 4 Ed Sheeran concerts a week. You know, a lot of vehicles coming and going to the site, and we have a significant amount of truck movements, truck and trailer movements, which creates real difficulty with the consent that we have. So that consent really is it's a placeholder because we have nowhere else to put a pack and save in Rolleston at the time of getting that consent. If we actually enabled that consent and activated it and constructed a pack and save in the middle of Rolleston Town Centre, we would suffocate the town centre of Wollaston. So the amount of movements, the amount of generation of customers to and from the site to a sole destination activity, we would really choke your town centre. And I don't think that's the strategic approach that Wollaston needs or wants. And I don't think that's where the district plan is wanting to head. Wollaston is growing at a fast rate. A Pick and Save is a regional provider of low-cost groceries, so it needs to be located in a regional area. And if we place it in the middle of Wollaston, we really will adversely affect the town centre.
So we've kind of gone a bit of a tangent to
Sorry,
your question,
yeah,
Commissioner, but ultimately what we're saying is we absolutely support retail in town centres. There's no question about that. But we also don't want to be restricted from the odd situation or special circumstances when you might need to apply for a resource consent to consider a supermarket outside of the centre as well. Currently, at the moment, there's provision only in the town centre in no other zone.
So out of desperation, we have located in the town centre, but that's not the ideal position for Selwyn district. Yeah.
Kia ora,
And
thank
that's
you.
what I was meaning. Yeah.
Kia ora, thank you.
You're obviously going to have a lot to say in future hearings by the sound of it. But in terms of the strategic objectives, generally supportive, I think that's fair enough.
Correct.
I will just focus on your, it's in the legal submissions, paragraph 4, it's just the summary about strategic direction, SDDI01, including maintain and enhance. You've been around the planning track for a fair while. Maintains and enhances comes up frequently. Sometimes it comes up as just enhances. In this case, the wording as notified as enhances. What's your view on the problem with adding maintains where you've already got a degraded environment? If a site is scruffy, for want of a better term, and you're been maintaining that scruffy, so is that an acceptable strategic outcome? Shouldn't you, aren't the strategic objectives supposed to be potentially outcomes focused about enhancing social, environmental, etc. well-being?
My submission in terms of, I mean, the first point I'd note is in terms of that maintains and enhances. When you look at the Section 32 report, they discuss that objective and provision with those exact words. So they just haven't expressly included them within the strategic direction. But I take your point, there will be situations, for example, when what we're seeking here again is flexibility. There will be situations when a development comes and locates in the district and it will enhance the environment. There will be other situations where it may just simply maintain that. But overall, if it's contributing to an environment that will be enhanced, it gives you that added flexibility, in my view.
So it's purely for flexibility.
Pure for flexibility. There will be situations, Commissioner, and I'm sure you're aware that there will be some adverse effects experienced by development. Not every single development can enhance an environment. There may need to be an offsetting or a compensation. It's simply around providing flexibility and thinking. I think the aspirations of most developers are to improve and provide a better environment, and obviously there's economic incentives for that as well if you're on selling things. The intention of the word maintains is not be aspirational, and you'll see that we've included maintains ands, not maintains or. So in my submission, it would be that it is achieving what you're suggesting, but it just provides that little bit of flexibility if you're not enhancing in every particular situation.
All right, I'll leave it there. Thank you.
Thank you. I just have one question on the relief itself. I'm not sure whether to ask you, Mr. or Ms. Parry. You did mention as well that the changes sort of quite minor in terms of the strategic objectives. What my question is SDUFDO1 on the table at the bottom of your evidence. The officer has recommended the words urban growth is located only in or around existing townships, and you're seeking a change to use the word primarily. So urban growth is located primarily in or around existing townships. what I heard from your submissions earlier was that you seek to be able to develop supermarkets outside of the centres, and you use the word centres. So what my question is what is wrong with the wording as it currently stands? Because it talks about townships. So the question really is for Ms. Parrish is, do you anticipate developing supermarkets outside of townships? Or is it just the zoning within a town that you're more concerned with?
The latter. It's certainly we want to locate within townships. It's the zoning within the township. And what Foodstuffs would really like is a really well thought out pack and save development in Rolleston.
Okay. Yeah. Well, in that case, I'm still unclear why you need to change the wording for.
So Commissioner, I discussed this at length with the planner, and it's interesting because I agree, if we were simply to put a pack and save which is intended within the township, we'd be consistent with that. What we're doing under the Selwyn district plan is planning 10 years ahead, and there's significant growth that's been achieved. And you'll be aware that there's a number of plan changes that are also proposed outside urban infrastructure boundaries and outside essentially townships. Now, if you don't have, the intention is not to change the outcome sought in that objective, which is primarily it should be all located, but there might be the odd exception where there's been a development outside of an infrastructure boundary that isn't considered within the defined terms of the plan. So those township, that's defined within the plan. We're trying to not cut off any potential flexibility and opportunities, noting full well in subsequent chapters that you would need to justify that on effects. You're not just going to locate something out of a town centre.
Just finally on that, would it not be fair to say that a standalone supermarket outside of a township would normally be progressed through a plan change rather than a resource consent?
It could be, Commissioner. Yeah. I don't believe, looking at the objectives and policies, that there's you would have to have a standalone site-specific situation, and you would have to advance every single provision for a plan change outside, because in a normal situation, when we go to seek plan changes for supermarkets, you're usually just adopting an existing commercial area plan provisions on a site, but there's no enabling throughout the entire plan. So it would be challenging to do that. Yeah.
Just because you brought it up, so you've got you've been granted consent to build a pack and save supermarket in the Rolleston township. Why did you apply for it if it's, I'm not understanding why you apply for it and you're not actioning it?
Good question, very good question. The reason we applied for it is because we believe that there is a high demand for a pack and save in Rolleston, and we own the site, and out of desperation of trying to achieve a pack and save development, at the time that was our only alternative.
It was a strategic decision to preserve the right to develop, and we are looking for a more appropriate site. Yeah.
Which leads me to my next question. I'm looking at your attachment to the activity status for a new supermarket, and there are 3 areas where an activity status would be deemed discretionary. Is that not enabling?
In itself, it could be considered enabling. The challenges, for example, and I'm just going from memory because I don't have the submission with us, but I'm aware of the table that's been put together by Oricon that you refer to. And for example, I think it might have been in residential zones, it's discretionary. But then if you go to the objectives and policies, it says essentially no non-residential activity. So while it appears to have an enabling activity status, the objectives and policies are very, very restrictive and directive. So you would never be able to, in my view, it would be very, very, very difficult to achieve a resource consent outside of those zones, in those zones with discretionary activity. Yeah. And that's why we will be appearing throughout the hearing to make submissions, exactly the point that you've acknowledged.
I'll leave that question there for now then. Thank you.
Yeah, but very good observation. Thank you, Commissioner.
Yes, interesting. I can see the issues that you may have with location. If the zoning allowed you to be in a general industrial zone, would you go there?
Yeah, so we've considered the appropriateness, but the challenge we have with a supermarket, for example, is it's a residential activity. When you look at the industrial zone here, we've got it over on the other side of the motorway, disconnected from your catchment that chooses to use it. Generally, that you might walk within 800 metres, people will walk to do the supermarket. It's meant to be an interactive community activity. We've called evidence on a number of occasions for hearings, which demonstrate supermarkets can often act like a community hub where you've got your older people, you know, walking on a regular basis to the supermarket. There's an intention for it to be compatible with residential environment. The challenge we also have in Rolleston is the, if we're looking specifically here, is the large amount of growth that is planned. And I don't know how many hundreds of metres it is from where the town centre is to where the end of the residential. But that's a huge walk for someone to go to a supermarket. And it would be even further if it was across the road in the industrial. If you were looking purely on perhaps car-based activities, perhaps, but a supermarket offering is a lot more than just car movements. Yeah.
And we're moving more to multiple modes of transport now. To locate a pack and save in the I-zone area, it's very divorced from the rest of the community. Even a pack and save shop, most customers would shop 2-3 times a week. So it's really important to be linked to your community and not separated, not just physically, but really kind of separated environmentally from the residential community.
So you don't think that the high level of traffic movements you were talking about earlier with a pack and save would be incompatible with the residential area and cause reverse sensitivity issues?
That's a really good question. A site needs to be located that can accommodate that. So it needs to be located potentially on strategic arterial roads as well, but not in the I-zone.
So the submission supports that there's a non-complying activity status for supermarkets in the I-zone. We're not intending to change that. And as Ms. Parrish has identified, there's also, when you look at across the district, there's a number of strategic roads or busy roads that move through residential areas. And that would be where Foodstuffs would be looking to locate a supermarket out of zone if they did.
Yeah. And that would link to the rest of the district as well. So quite an attractor for the whole district.
We're not seeking to enable a supermarket without comprehensive and detailed assessment on things like traffic effects, simply that you can have an opportunity to be considered. Yeah.
Thanks. Just a question. So paragraph 25, you referred to, of the legal submission, you referred to the Canberra Regional Policy Statement. And you identify that it provides for recognised new commercial activities primarily directed to the central city, key activity centres, neighbourhood centres. So just a question for you, do you think that strategic directions 05, which is vibrant and viable centres, gives effect to that?
I do.
Yes, you do.
Well, so we support it. They talk about the word preferred location, and that's accepted.
Yep. And so you haven't sought, Foodstuffs haven't sought any changes to that strategic direction, and that's sufficient for you.
Yeah.
Okay. So I'm imagining that there will be, we'll probably hear from you again with the more detailed chapters as well in terms of what you're trying to achieve in town centres. Yeah. Thank you. Yeah. No questions.
Thank you.
Would a supermarket be considered urban development?
Yes. So under the NPS, urban includes obviously business and residential.
And so can you just remind me in answer to Commissioner Solomon's question, I think you said the harshest consent category for a supermarket outside of a town centre is discretionary at the moment in the notified plan? Or?
Non-complying, and then so non-complying in the I-zone area. Yeah. Sorry, this is just off memory, but it is in the submission content, which is supported, and then it is discretionary in things like mixed use zones, commercial zones and residential zones. on the face of it, that sounds great. The challenge is we've got very restrictive and directive objectives and policies which would not support that development. So we'll be seeking in chapters not to change the activity status potentially, but to seek for some enabling objectives and policies.
Just a question about the change you're seeking to SD D101, which is page 1 of your appendix 1 of the legal subs, and it's the maintains and enhance words in green. I'm just interested in, sometimes we have maintains and enhances, and sometimes maintains or enhances, like you said. And the word and implies it's a conjunctive obligation, so you must maintain and enhance at the same time. I'm just wondering if that's physically possible, or
whether it's more appropriate as or I mean, that's a good question. I think that if I was arguing for a supermarket and there was a maintain and enhance and you could demonstrate maintain,
yeah,
I'd say that you could achieve that, or would be more appropriate in terms of writing. And or was the reference when I read the Section 32 report to understand the reasons around this particular direction and why there wasn't sort of that general maintain as well as enhance. Yeah. And they referred to the purpose of the strategic objective is to effectively to maintain or enhance the amenity of Selwyn. Yeah. And in my view, that's appropriate, but it's not reflected in the direction. Yeah. And can I also say there's law that talks about what the words maintain means. And generally from an adverse effect perspective, that means that it is inconsequential. So it doesn't mean there's no movement at all, but it is, you know, it's obviously an inconsequential effect to the overall environment. And these are intended to be those big umbrella provisions. Yeah.
All right, thank you very much for that. No further questions from me, but thanks very much for coming. Did you wish to add anything else at this stage? No?
Thank
you
very much.
All right, thanks very much.
Thank you very much.
So the next submitters on my list, Transpower. Good morning and welcome. Would you like to introduce yourselves to us, please?
Thank you, sir, and commissioners. Good morning. My name is Rebecca Eng. I am an in-house planner at Transpower, and I lead the RMA policy workstream at Transpower. I'm joined by Ainsley McLeod, who's our independent planning witness today.
All right. So I think you've been sitting here earlier on and you're aware that we've read the pre-circulated material, so thank you very much for that. But you are welcome if you wish to summarise key points, or we can just proceed straight to questions if you like.
Yes, I noted the Commissioner's preference for brevity in terms of the introduction, so I can just give a general overview, much like Mr. Liggett, who's appeared earlier from Kāinga Order. The overall sort of approach to my evidence was to provide an introduction to Transpower and the National Grid, and the nature of the particular National Grid assets in the Selwyn district, which you all may have noted are quite wide-ranging in terms of scale. The National Grid plays a critical role in New Zealand's economy and providing for the economic and social well-being of New Zealanders. In the future, the grid will continue to play an enduring role in the electricity system, and furthermore, a key sort of strategic matter for Transpower at the moment is the role that it will play in meeting New Zealand's carbon zero aspirations. So that's a front of mind issue for Transpower, and in terms of its physical built assets, that is about maintaining and operating and taking care of, upgrading the National Grid backbone that we already have, and to make the most efficient use of the existing assets, but then also turning our minds to what we might need to do in the future to enable a significant uptick in further renewable electricity generation sources. And critical to that is the extent to which planning documents throughout New Zealand give effect to the National Policy Statement on Electricity Transmission that will make or break Transpower's ability to respond to the carbon zero challenge. And starting with this first hearing, I concur with the evidence of Ms McLeod in terms of how matters such as operation, maintenance, upgrading and development of the national grid, among other matters that are covered in strategic directions, will give effect to the NPSCT. That's all from me at the moment. Just to clarify, I'm a planner. Yeah.
No, I've got questions for Ms McLeod though.
It's okay.
Okay, thank you. You'll hear from Transpower over the course of these hearings often. Quite often Transpower's evidence is around giving effect to the NPSCT, and I also draw your attention today to a specific policy in the RPS that relates to the national grid only, which is policy 1634. And I've quoted the whole of that policy in evidence, and I highlight again for you today because you do have a lot of evidence before you in relation to the infrastructure provisions. But that evidence hasn't really contemplated how that policy 1634 is given effect to in the infrastructure strategic objectives. So it's just a matter that I want to highlight as something else for your consideration beyond just the more general infrastructure provisions. My evidence is concerned with giving effect to the NPSCT and that RPS policy, and also the way in which that's achieved in a strategic directions context as opposed to the whole of the plan context. And I think it's important to highlight that difference. Giving effect to those provisions, there really are three things that need to be done. It's recognising providing for the benefits by providing for the operation, maintenance and upgrade of the national grid. Then it's the managing the effects of the national grid and managing effects on the national grid. And those effects can be both direct effects as well as reverse sensitivity effects that you hear a lot about from other infrastructure providers as well. The district plans can do this in three ways, really. You can rely on just generic, important or significant infrastructure provisions, or the district plan can include provisions that are specific to the national grid or a mix of both. And my preference as a planner in terms of efficient plan writing is probably to have that mix of both. And I think the RPS does that already with generic, significant infrastructure, critical infrastructure provisions, as well as a provision that is specific to the national grid. My evidence just supports some minor amendments that are necessary to the strategic objectives to give effect to the NPS and just tighten up a little bit of expression as well. In terms of the role of strategic directions and the strategic objectives, my evidence highlights the need for the role of those provisions to be really, really clear. And I have promoted some amendments to make it clear that there is no hierarchy between objectives in the plan. That was my understanding, and I know there's evidence before you that says completely the opposite, and perhaps that's my point, the fact that parties have read the plan as notified and made different assumptions about the role of the strategic objectives. So I make that point in my evidence, and also just being clear that the role of those provisions in future processes goes beyond just the consideration of resource consents, and I highlight there also notice the requirement for designations is perhaps something that you want to give some thought to. I can probably leave it there.
All right, thanks very much for that. Mark, any questions? Yep. Lindsay?
Go to the last page of the evidence, you've got your
Perhaps I should highlight a typo there too in the second amendment to the objective 1, community needs, I've reproduced both the notified version as well as the suggested amendment version.
But looking to your suggested amendments to the strategic direction, and this very much leads on to your comments about a bit of uncertainty potentially amongst some submitters about what the role of strategic direction objectives are and the way that they fit through. You've introduced some amendments to that, and including your first one, including consideration of resource consent applications and notices of requirements. When I was reading this, I had put that clearly into the term implementing the district plan. So is there any need to actually go to the level of specificity about saying resource consent applications, notices of requirements? What does that add over and above implementing the district plan?
No, I don't think it does. I think implementing is sufficient.
Okay. And then you talk about no fixed hierarchy, but then later on it says there is no hierarchy. Why the term fixed hierarchy?
The word fixed is something that I borrowed from the Environment Court decision in Queenstown. I think that the key point there is that I'm suggesting that the guidance for this chapter, the strategic directions chapter, should say that there is no hierarchy between objectives throughout the plan. So that no greater weight is given to a strategic objective compared to an objective in another chapter.
Yeah, I think that this will be subject to a number of submissions about what are the relevance of the strategic objectives, and other objectives need to give effect to those. Is that what's the optimum? What's the point of strategic directions if you've got a lower level objective on or another chapter on something to do with the transmission lines?
Yeah.
Where does that fit, in your view, optimally in relation to the strategic directives?
I don't think that objectives can or should implement other objectives in the plan. I think the Act's clear that policies implement objectives and rules implement policies, not objectives implement objectives. Or if for instance, I know some submitters have suggested there be strategic policies, I don't think a lower order objective can implement a higher order policy. So I guess I'm guided by the Act and what provisions in the plan ought to do in section 32 as well. I see strategic direction as doing something like what the Ministry for the Environment guidance is. It's significant issues for the district, that it's broad overarching guidance for district-wide issues, nationally significant issues, regionally significant issues. And I agree with the section 42A author that the remaining provisions in the plan ought to be consistent, and there might be tensions that need to be resolved, but there ought to be consistency through the plan. The strategic objectives are the outcomes for the district at the broadest level. And I guess a metaphor might be that they're the bones of this plan document, if you like, and the remainder of the chapters provide the flesh on those bones, including policies that might say a little bit more about how you would implement those broad outcomes.
Okay, but if you've got a strategic objective, like the infrastructure objectives here, for example, and then you've got also objectives in the infrastructure chapter.
Yes.
And if there is internal conflict between them, potentially, wouldn't you go to the higher level documents to resolve the higher level objectives to resolve potential conflict?
Yes, but not necessarily in a hierarchical or weighting sense, and more of that overall judgment sense. That would help you to understand the more specific objectives, if you like.
Okay. Might ask some other witnesses about this later on, because it's a relatively have been a few submissions on this.
Yes, yes, and I think that a number of district plans have taken very different approaches to the way in which you might understand strategic objectives. And perhaps my position, I'm leaning a lot on the outcomes in Queenstown as opposed to, say, Dunedin, where the strategic objectives are more method-based. This is how we achieve what we're doing in the latter order documents, the latter chapters, I mean.
All right, well, we'll leave that one aside for now. The old chestnut in planning, or the recent chestnut in planning about minimise versus avoid, remedy or mitigate. So I haven't been through your submission in a huge amount of detail, but every time there is the use of the word minimise in there, you're requesting a blanket removal of that and avoid, remedy and mitigate. Okay.
Yes.
I know some plans have gone to the extent of actually defining what minimise is, taking the dictionary definition. So what is really the benefit of going avoid, remedy, mitigate, or against minimise in this context at a strategic level?
Well, in my evidence, I make a number of points about my discomfort, if you like, with the use of the term minimise. And one is, it can possibly be understood in two ways. One is to make minimal, or one is to do something to reduce the effects. And that would deliver two different outcomes. So that's one point. The next point is that the MPSET doesn't require Transpower to minimise effects. It contains a lot of directives around avoid, remedy or mitigate. So in the context of the national grid, then I believe it would be inappropriate to require Transpower to minimise effects. And in fact, if you think about it, if you were to understand minimise as to make minimal, it would be quite challenging to build a new transmission line, an overhead transmission line, and make those effects minimal.
Like reduce adverse effects to
Well,
a reasonable extent practical in the circumstances, which I think is sort of akin to the dictionary definition.
Or to make minimal. I did some work on dictionary as well, and I just don't know if it's as clear, and I don't think the MPSET requires it, and it's certainly not a requirement of the Otago of the Canterbury RPS either.
Okay. And the MPSET obviously has a very important document. It's it's higher up in the hierarchy.
Yes.
So you're really just seeking broad alliance with the principles in the MPSET, which is produced 8 to 10 years ago. Yes, it's been in place for a wee while.
It has, and it has quite clear direction around the way in which effects of and on the national grid are to be managed. And my evidence is seeking that there's alignment so that the MPSET is given effect to.
Okay. All right, well, I'll leave that for now. Thank you.
No, I'm fine.
Gary?
Just one further question. Paragraph 64. This follows on from the discussion on minimise and avoids, remedies, mitigates. I was just going to ask you about the last words you've added to the objective that can limit the extent to which adverse effects are avoided, remedied or mitigated. Is that coming from the NPSET, those words? Is there an emphasis there on limiting the extent to which adverse effects are avoided, remedied or mitigated?
Policy 4 of the MPSET talks about the extent to which any adverse effects have been avoided, remedied or mitigated. So
Policy 4.
Yeah.
Okay, thank you.
Cool. Rowan? Malcolm? Andrew?
Yes, thank you. So just referring to the last page, we've got the proposed changes and track change. And in particular, just looking at objective 1 and objective 2. And do you think that there is overlap or even conflict now between these in relation to upgrading and development. So objective 1, upgrading and development of infrastructure is protected, no qualifiers. And 2, upgrading and development is enabled, but with a series of qualifiers around its adverse effects. Do you think there's any conflict or overlap between those two as you've amended?
No, I had understood, and I think this goes to a question that was asked earlier today around objective 1, the community needs objective, that I think that does have two parts. One is meeting the community's needs, with the first part of that policy, and the next one I had read and understood to be the protect development, like managing the effects on infrastructure, whereas the next policy, the next objective deals with enabling, and then, but with the qualifier around the effects of. There would be other ways that you could write this. You could write this having those three limbs, if you like, as 3 separate objectives. So you have an effects of and effects on, and an enablement kind of approach. And I think that's the approach suggested by some of the witnesses. And that would do the same thing, but I don't think that there's an issue with what's in front of us now with the 2 objectives.
Okay, thank you.
Just following on from that, if I take you to your paragraph 58. And you change, you're asking us to consider there. And I can understand how operation and maintenance probably can be protected. But I'm struggling to understand how upgrading and development can be protected, given that there are future things that haven't happened yet. How can you protect something that hasn't happened yet?
I guess this unfolds a little bit when you come to the actual provisions from a national grid perspective that would apply to the national grid. The upgrading and development of the national grid can occur within the same or similar corridor, but may involve activities such as larger towers, high voltages, and that kind of activity. I don't know if you've got some more examples.
To touch on the development example, in the context of a corridor, how we see that is where, for example, there is a corridor protection in place for that piece of line asset, and we are asked by a customer, for example, to move that asset to make way for state highway interchange, for example. And in that instance, the corridor would still continue to apply, or our ability to be able to move is preserved.
So I'm not sure if you answered the question though. So the way in which upgrading and development is protected is, or how would that occur?
For the national grid, the way in which Transpower sees the national grid being protected is by corridors and yards that effectively manage or avoid some activities within the vicinity of the national grid. And that's to give effect to policies 10 and 11 of the national policy statement that does make reference to upgrading and development. Some of the ways those implementing provisions, if you like, work are to ensure, for instance, that there is vehicle access maintained to the towers, so that if those towers need to be replaced, painted, foundations replaced, the location of the tower relocated somehow, there's the ability, that ability is not compromised in the future, and Transpower can continue to get the most out of that asset or a renewed asset.
And you mentioned specifically corridors and yards. In terms of the district plan that's in front of us now, is that adequate in that regard?
In the most part, there are some specific submissions that no doubt you'll come to when we get to the infrastructure and energy chapter. But there are corridors and yards provided for.
Okay. And just your paragraph 64. And it's again touching on this issue of minimise versus avoid remedies or mitigates. There's a body of view, or there's a view of that I come across quite a lot, that just simply parroting the Act, avoid, remedy, mitigate, adds no value at all to the statutory direction we already have, and it provides no additional guidance whatsoever to decision makers. And that it's the role of plans, regional and district plans, to actually take that a little bit further and give some meaningful direction to a decision maker rather than just parroting the Act, because we know what the Act says. What's your response to that?
Yes, those views. I see, I have thought long and hard about other ways you can do this. And I think that to some extent, the policies that say how you avoid, remedy or mitigate that follow in the infrastructure chapter can assist, because there are certainly the guidance in the MPSET says different things about effects on different values, if you like, and that's quite specific and nuanced in the MPSET. So you will see in future hearings, I will be suggesting the use of terms like seek to avoid in respect of significant Indigenous vegetation and habitats. It's certainly more nuanced, and the question is how much detail needs to go into the strategic directions objective versus how that might be explained further on in the policies. What I've said in my evidence in relation to something else is that the key concern here is that nothing in the strategic objective would prevent the full suite of approaches to the management of effects and the subsequent policies that will implement these.
All right, and just to the 42A reporting team, just while it's on my mind, I can't recall if the plan defines minimises at the moment. I don't know. So when you report back to us in your reply, can you come up with a definition of minimises for our consideration, just so we can have that option before us and feed into our deliberations, please? Just in terms of the role of the strategic directions, and you said during your verbal presentation that you're guided by the Act, and the Act provides for a hierarchy of instruments. So we have the Act itself, national policy statements, regional policy statements, and district plans sitting down the bottom. So there is a hierarchy. There's superior instruments at each level is to be guided by and give effect to. So in that context, what's the point of having strategic directions in a district plan if they don't form a type of superior direction for decision makers?
I still see strategic directions as providing that high level overview, the broad definition of the outcomes sought for the district as a whole. What I'm suggesting is that they're not afforded greater weight, such that you end up with a debate of, oh, but our thing's important too. And so, and you've heard that today around from Kaingaora suggesting that, hang on, our stuff's really important, so that needs to be a strategic. And Transpower would argue the same, of course, that we're nationally significant and therefore you need to put as much as possible about the national grid up front. I think an approach where you say this is broadly the outcomes that are sought, and these are explained and expanded on in the latter parts of the plan is a more appropriate approach.
But even if that context, if they're providing a broader overview of the important issues for the district, if it's unclear what the lower order provisions are actually requiring, wouldn't it be sensible to refer to the superior provisions?
And I think that the guidance provided in the Queenstown plan example does that, but it doesn't give weight, a hierarchical weight. It gives you the ability to apply that guidance and assist in the understanding and interpretation of the plan without saying, when we've got this objective here and this objective here, we're going to, this one's more important. I see it more as a read in the whole.
All right, thank you very much. No further
Thank you.
questions. So that brings us to the end of this morning's submitters, and so now we're adjourning until 1:30. Thank you. plan. And at this stage in the process, we're hearing from Rural Forest and Bird. Mr. Jennings, good afternoon, welcome. So thank you very much for pre-circulating your legal submissions, which we've all read. So you might be pleased to know you don't need to read them out loud to us. But you're very welcome if you wish to highlight key points for our benefit, or else we can proceed straight to questions, but over to you in that regard.
Thank you, Commissioners. Basically, what brings Forest and Bird here is the overview wording in the strategic directions chapter, which basically gives the strategic directions primacy over the rest of the plan. At least that's the way Forest and Bird views it. Forest and Bird doesn't view that the strategic directions should have primacy over the rest of the plan. Forest and Bird considers that it should give guidance to the rest of the plan and the plan's development. But in terms of when resource consents are considered in that, if it's not clear direction through those, say for example, the Indigenous Biodiversity chapter, then resort back to the strategic directions would help guide those decision-making processes. And so that's basically what brings Forest and Bird here today. Forest and Bird also considers that the protection or maintenance of Indigenous biodiversity isn't expressly covered. It considers in the strategic directives. Forest and Bird considers that's a key strategic issue for the district, and considers there is a gap in it, and it could be filled with the suggested wording from the Department of Conservation evidence. So happy to take any questions. Hopefully not many.
All right, thank you very much, and thank you for that very concise summary. It's helpful. So we'll see if we have questions, and Andrew will start at your end of the table.
Yeah, thanks for the legal submission. So I do have a question. So paragraph 4, Forest and Bird refers to a gap in the strategic directions around identifying key resource management issues facing the district, and that there's according to the submission, need appropriate management of Indigenous biodiversity is a key issue, and therefore we need some wording to fill that gap. So you've talked about one of the issues that creates if you have strategic directions having primacy over other objectives and provisions in the district plan. Do you have any examples of that you can point to in other district plans, or is it just a theoretical issue? Do you know, have you actually seen this play out in discussions or through consents or whatever through other district plans in the country?
Sorry, just to clarify, where are you asking me? Is there another plan in the country that has strategic directions that have primacy over the rest of the plan?
Yeah, and that it's created an issue because there's been a gap, and the gap has not been filled. Do you know if there's actually an actual problem, or versus theoretical?
I'm not aware of any other plan that has primacy, has a strategic directions chapter that has primacy over other chapters. So I can't really guide you on that. In terms of the gap, Forest and Bird considers that it doesn't expressly address the Indigenous biodiversity of the district within the strategic directions.
Sure. And so as a follow-up question, then would you, following that line of argument, then you would anticipate or expect the strategic directions to cover every section 6 matter, every section 7 matter, section 8, all the key components in the RMA that the district plan should give effect to, should all be included in this strategic directions chapter?
If the intention of the strategic directions is to have primacy over those other chapters, then it should try to give effect to those higher order planning instruments.
Okay, thank you.
Welcome. No. Raymond?
No,
Nicole? Gary? Lindsay?
Sorry, no, I think Andrew has basically put the question I would have asked, so thank you.
And Mark? Okay, Ms. Jennings, just one follow-up question from me, and it stems from your paragraph 30. And following on from the earlier question, if the strategic directions did have primacy or priority or were superior to the other objectives further on in the plan, if in the case that there was a higher order planning provision that was omitted from those strategic directions, wouldn't a decision maker, say on a resource consent, nevertheless be obliged to give effect to that higher order provision anyway, notwithstanding the fact that it wasn't repeated in the strategic directions?
I think you're probably correct there, Commissioner, that if, when you're considering those resource consents, if you identify there is a gap going up the hierarchy, and then if you do have to have recourse to the NZCPS or whatever it may be, then you would need to fulfill that obligation. And Forest Bird would probably make sure that was complied with as well.
Yeah, I imagine they would, yeah. Would that be a case of that the strategic directions maybe not covering the field, therefore the higher order instrument would take priority anyway?
Yes, I think you're correct there, Commissioner.
Yeah.
I think perhaps the problem here, or not problem, but issue that Forest and Bird sees is the confusion that could arise with plan users that are reading one chapter and then they have to refer back to another chapter, and that chapter doesn't give effect to a higher order planning document. Then you've got to refer to a higher order planning document in order to get their resource consent over the line.
Yeah. So the outcome might be one that would be appropriate, but it would be an inefficient process, is it?
I think that's correct, Commissioner.
All right, well, thank you very much for preparing the legal submissions and pre-circulating them and coming in to answer a couple of questions. We appreciate that. Thank you.
Thank you, Commissioners.
Now we're running a little bit ahead of schedule. Is Foster Commercial here? No? Who are you two representing? Are you happy to go now? Yep, great. Let's do that. Thank you. So good afternoon and welcome. It's good to see the Canterbury Regional Council here, and we just had a discussion about superior instruments, and of course the RPS is one of those, so it's good to see the council here in that capacity. So if you want to introduce yourself to us and then either summarise key points, or if you're happy to go straight to questions, we could do that as well, but up to you.
Good afternoon.
Excellent, thanks very much for that. Well, Mark, we might start with you at that end of the table this time.
Thank you. My question is around paragraph 29 in the legal submission on page 7. In fact, I've got 3 questions that flow on from each other, so I'll ask all 3 and you can see how you answer those. Is it possible that the housing market is moving so quickly, that much more quickly than anticipated, such that the housing estimates in the latest HBA are already out of date? If so, would this mean the recent changes in the Canterbury Regional Policy Statement aren't giving full effect to the NPSUD, and because there is still a shortfall in supply? And if this was the case, would this mean that your submissions restricting growth to the FDAs is in fact insufficient?
That one, thank you. In terms of the whether there is a insufficiency of supply already, there are mechanisms in the NPSUD around monitoring and capacity assessments to undertake the assessment of the sufficiency of development capacity. There are also mechanisms in the NPSUD around responding to any shortfalls in capacity, and there is a requirement for local authorities to respond in that regard. I'm not in a position as council to say whether or not we do have, in terms of the most recent monitoring, a shortfall in supply other than what I have seen in terms of the most recent capacity assessment. It does show over the medium term a potential shortfall in Selwyn, which has been addressed through change 1 to the regional policy statement.
Thank you. It's just that it could be observed here, for example, that there is a shortfall in the market today, which would lead to, if we have a tension between the regional policy statement that says restrict to the FDAs and other submitters saying, well, actually there's a shortfall today, that restriction is undue and doesn't address the housing need. There is no surplus in capacity today. And I'm just trying to tease out what that means. Does it mean that in your submission that the district plan should give full effect, that if the regional policy statement gives full effect to the national policy statement, we restrict all growth to the FDAs and some subsequent process will allow growth outside of that?
Yes, in my view, there are mechanisms. So the potential shortfall over the medium term has been addressed through change 1. So in my view, that is where development should be occurring at this time. Any development outside of that would be a matter for a future process following the monitoring that's being undertaken, future capacity assessments and the future development strategy. And I acknowledge the other submitters and the suggestion that there is a tension between being responsive and what is in the regional policy statement in terms of a very directive framework around where growth should occur. But I would note the NPSUD itself does in terms of responsive planning, and I think it's objective 6. So whilst councils are required to be responsive, there is also the obligations around being integrated with the infrastructure planning and also being strategic over the medium term and long term as well.
Thank you. This may be a topic that we return to when we come to the urban growth chapter. Thank you.
I may have the benefit or potentially the disbenefit of being from Wellington, and there seems like there's been a huge amount of strategic work done in terms of plan change 1 to the RPS and so forth. Now that was made operative very recently, I understand.
Yes.
But the commencement of that work predated the current NPSUD, didn't it?
The commencement of the work did, yes. Whilst it was going through the streamlined planning process, the change did take into account the new NPSUD.
So I guess my question is there another body of work which needs to be done in terms of what PC1 provides to actually give effect to the NPSUD?
So the change 1 to the RPS is a planning response to an identified potential shortfall in capacity. There is ongoing work as is required under the NPSUD in terms of monitoring. There is another housing and business development capacity assessment that is being worked on, and there will be another future development strategy as well. So the NPSUD, in terms of that evidence base for those planning responses, it really is an ongoing obligation of local authorities.
Thank you. I guess my other question is in relation to your Para 75 in relation to a proposed new rurally based strategic objective. We've had a number of submitters, obviously from the, if you like, from the rural sector, the productive farming sector, etc., which actively support that. And your original submission, or further submission, actually supported that view. Do you think that from the regional council's perspective, that it warrants a particular strategic objective in its own right, or it can't be subsumed into the existing objectives. I see you've supported the view of the officer on that, but in an ideal world, considering how important rural production activities are to the district and to Canterbury, is it of sufficient magnitude to justify a strategic directive in its own right?
Yes, so the view was looking at the further submission in support of Horticulture New Zealand's submission, and they had suggested the insertion of an objective. The council has reviewed the recommendation of the Section 42A officer and considered that the inclusion of the reference to highly productive land in the strategic directions objective number 1 did sufficiently cover that issue and deal with that, and that it did warrant recognition in the strategic directions.
But not in its own right, as being an issue in its own right, or an objective in its own right.
I guess it wasn't considered necessary to be an objective in its own right, given that it was captured in that objective number 1.
Okay, well, thank you.
No, nothing for me.
No further questions from me either, but thank you very much for coming in and answering our questions so clearly. Thank you.
Great, thank you for your time.
Foster Commercial. Good afternoon and welcome. So I'm not sure how long you've been sitting there, but just to let you know, as we have with other submitters, that thank you very much for pre-circulating your evidence, and we have read that, and so there's no need for you to read that aloud to us, but you're very welcome to highlight key points, or we can go straight to questions, and if maybe you could introduce yourself to us as well.
Thank you for the opportunity to talk. I'm here on behalf of the Foster Commercial. I'm a practicing planner with Davey Lovell Smith. Foster Commercial are a family business. They have strong connections with Rolleston. They own a lot of the land that have joined the old town to the east, which has now been incorporated in some of the new growth areas, including, of course, Foster Park. And they I think were owners of land in Farringdon, and they are now the owners and operators of South Point, which is, as far as I know, it's only new, smaller commercial area in Rolleston. And I've assisted Foster Commercial in a number of consents which were required for businesses within South Point, and also assisted people who had come to them looking for places to establish their business, their operation. So I'm familiar with some of the difficulties that they face, new businesses in Rolleston trying to establish, these include hospitality, retail, community and cultural activities. I note at this stage that while the details of the zone provisions are not being considered today, that it is appropriate the panel is aware that at the strategic direction stage that there are proposed provisions in the neighbourhood centre zones which include limits on gross floor areas for certain activities. The submission seeks to simplify and make positive the strategic direction objective 5 relating to vibrant and viable centres. The simple version that we are advocating is just that Selwyn activity centres are the preferred location for shopping, leisure, culture, entertainment and social interaction. This would bring it in line with other objectives which are unqualified. The Foster commercial submission also seeks a number of other amendments to the zones, which we'll deal later, which relate to impediments to establishing businesses. My evidence sets out the reality of that small neighbourhood centres do not affect the viability of larger centres. So there is no need to limit the size of activities within the zone. I discussed the report relied on by the 42A report and note that there is no clear basis for concluding that smaller centres need to be subject to limitations on individual activities. I think that's covered in sections 9 and 10 of my report, my evidence. And I also draw your attention particularly to the words that sit at the end of the objective 5, which says, actually you sort of need to read the whole thing really. Selwyn's hierarchy of activity centres are the preferred location for shopping, leisure, culture, entertainment and social action in accordance with their anticipated role within the activity centre network, which if you read it carefully, is actually really quite an odd addition. It to me doesn't really quite make sense because it seems to be relating back to people's preferences. For the above reasons, I consider that it's confusing and inappropriate at this high level of strategic directions to refer to those last words in accordance with their anticipated role when it's referring to people's choices. And I note that while I don't think the word hierarchy is essential at this level, I have no concerns with it remaining, as it indicates probably a scale of size of zone.
All right, thank you very much. Let's see if we have any questions for you. Andrew, starting with you.
Yes, thank you. Just rescan your evidence and correct me if I'm wrong, but I didn't see any reference to the RPS in chapter 6 in there. Just wondering whether you had considered that as part of the context for the submission, because RPS chapter 6 clearly talks about key activity centres and a hierarchy and activities commensurate with and consistent with their role in that centre.
Yes, and I don't have any necessary problem with that. I'm certainly highly aware of the key activity centre policies and objectives in the RPS. But as I point out, what I'm talking about are the smaller centres, and there's no reason to think that they in any way endanger the viability of those larger centres.
Paragraph 9, you've talked about, I think in paragraph 8 above it, I guess you referred to property economics report around controlling commercial activity and needing to have a significant adverse effect in a commercial centre to affect its potential viability. And you said the situation is rare and extremely unlikely to occur. Just wondering, do you have any examples?
No, I don't have any examples of a small centre affecting a larger centre.
Yeah, that's what you're saying, right?
Yeah.
And is it in part because it doesn't occur, because there is no adverse effect, or is it in part because a lot of district plans have provisions in place that manage large commercial developments in small centres to avoid an impact on other centres? I think it's the former.
I think it's for two reasons. Things trying to locate where people know that they're going to be well, people will come to them, and the size and the cost and various things, and there's a kind of a natural way or order of how things will happen. But I think it's also very much because of the fact that you're not allowed to actually limit trade competition, use that as a basis, and so you have to have a significant effect, and the chance of a small something happening in a small centre having a significant effect on a large centre is just very remote, and I just can't think what it would be.
And also in paragraph 9, you say any additional zones created in greenfield areas are subject to detailed scrutiny. And that's the reason why you don't see the necessity for the strategic direction and the wording that it is. Would not a additional zone in the greenfield area benefit from having a direction and strategic direction around the extent and quantum of activity, commercial activity in it though, as a guide?
No, I don't think so. I think you need to keep them as open as possible. Some of them are being fully used by preschools. You need an opportunity for everything that's not going to go in your main centre. It's not going to go in industrial zones. You need to be able to keep yourself open for that. And there's just a really wide range of activities that don't fit in any of those places. And you probably wouldn't necessarily want them right in the middle of a residential area, although some of them can. Obviously, preschools do that all the time. But you're second guessing stuff, and people have all sorts of businesses. And I've had experience with the dance school that's been trying to be established and was highly successful at South Point. It's so successful it needed to go somewhere else. Fortunately, timing wise, it's in the industrial zone. It's an I zone. It's permitted there, but it won't be in the new plan because it's more restrictive, because it's adopting a more restrictive approach rather than effects-based. So I think you need to be very open to letting small centres in the new residential areas being as free as possible. The main restrictions would be in relation to their impact on the immediate area rather than impact on the KAC.
So just one final question. How do you keep the centre small?
Oh, it's zoned. It's zoned, and you have to come up with some pretty good assessment of that. And very recently, I can say, as of last week, there's an application being considered and at a higher level for subdivision and development, and the applicants were asked for an economic assessment in terms of impact. It wasn't on the KAC, it was on another close by centre. So there doesn't seem to have been any issue that could have been a problem.
Okay, right, thank you.
Raymond? Nicole? Gary?
Yes, thank you. Just one question relating to the hierarchy and the trade competition discussion just entered into. Yeah, it's quite common to consider trade competition between, say, competing supermarkets and that. But I must say I've not seen that principle applied to the retail hierarchy or shopping centres competing with each other. But you're saying in your evidence that is a valid consideration.
No, I'm saying it's not valid.
It's not a valid
Not
consideration.
valid.
Okay.
And the reason that they give you for this hierarchy or for in there indicates that it's a problem with little ones affecting the larger ones.
Okay. Right.
Yes, I've got a question. With regards to, you just mentioned about the land could be zoned, okay, with regards to a commercial area. With regards to a change in zoning later on that could be requested by an applicant, for example, you could have a residential zoning and then an applicant could come along and actually say, well, I want that zone commercial. And with regards to impacts on the surrounding community, like reverse sensitivity, you may have a developer who's put on a no complaints covenants that they cannot object to anything that the developer wishes to do. How would you handle that under the scenario of managing effects of a neighbourhood centre?
Well, if it was to be rezoned afterwards, in terms, it would be something that I think people looking at it could take that into account. And even if there are no complaints covenants, it doesn't mean that when you're looking at rezoning, you couldn't take potential impacts into account. It just means those people can't complain. So it could be taken into account, and it should be taken into account if you are putting it within an area that's already fully residential.
Good afternoon. I'm interested in your initial comments about the use of qualifiers and objectives and how this one is, this SDDI 05, it has a qualifier in there.
So I'm just going to make sure I've got them in front of me. And I was going to check that before I came. No, unfortunately, I don't have them in front of me.
Just paragraph 6 of your evidence, I think.
Yes, I know that I said that, but I haven't, sorry, I didn't go back just before this hearing to check exactly that there was absolutely no, but I think they were generally kind of a positive statement.
Yeah, no, I understand all that. I'm just thinking about what potential changes could be made to that strategic objective. Because we are being asked for quite a few qualifiers by a number of submitters on a number of strategic directions, like putting in except in the case of
right.
X,
Well,
Y,
I mean,
Z.
I'm not saying that strategic objectives shouldn't have qualifiers, but to me, that the reason for that qualifying should need to be a pretty important, significant matter.
Yeah.
Not a lower level matter.
Okay. And if you strip it right down, that particular objective which we're focusing on, which is SDDI 05, about that is Selwyn's activity centres are the place to do leisure, cultural entertainment. It's a statement of fact. It's not that's where things happen, where these things happen anyway, rather than providing any direction.
Well, I would have thought that it's actually reinforcing that there'll be areas that are set aside for that purpose.
Okay, but without the word hierarchy and without the qualifier.
Well, like I say, now in terms of hierarchy, in terms of location and size of the area, I'm happy with that. If that's what the hierarchy is, if it starts being the basis of certain other controls, I'm not so happy. So I don't have a problem with the hierarchy because it does actually play out in everybody. That's what's happened to date, and that's what works.
Okay, so if you leave hierarchy in that strategic objective, and you don't have the qualifier in accordance with their anticipated role, what's the purpose of the objective then?
Well, because I know what's down the track.
Yeah.
I know that there's these restrictions that I don't think are reasonable. And if that stays in there, I can just see that it could be used as some sort of basis for that. But also, I just don't think it reads very well.
Yeah, I can accept that it might not read very well, but I think what I'm trying to get to is the nub of the objective, what is actually trying to be achieved by that. So there are various different activity centres, different sizes, different locations, different purposes, different functions and so forth that have a hierarchy, or there's a gradation there which says that the town centres do this, and moving down, if you like, to the smaller centres.
Well, that's why I don't think the word hierarchy is necessary, but I think it's not necessarily a problem. But I think the main point about this is to say, this is where those things are going to happen. We're going to provide for them. They've been provided in the past. We would like them to be the focal point for those kind of activities, as opposed to being in somewhere else like the residential or the rural zone.
Okay, so if you've got a town centre, which you would expect the sub-regional activities to occur, and you've got your smaller centres, which are more on a convenience basis, if you like. I'm not familiar with Foster Commercial's property holdings, I have to say, but presumably the offerings there are very much focused on the immediate catchment.
No.
They're not?
No. Most of these smaller places, you'll find, there'll be the dairy, usually a larger kind of dairy. But everything else is not necessarily local at all. One is hospitality, and that's classic. People will travel to go to a decent restaurant.
Yep.
There's a dance school. There's just those sorts of activities. They're not necessarily that catchment based. And like I say, some of them have actually just got a preschool on them. they've got a great variety.
So are there any activities which are more appropriately focused upon being in a town centre as opposed to being in a
Well, I
smaller
don't
one?
think, I know it sounds a bit cheeky, but I don't know whether that's the role of planning, that we should decide which one should go where. They can work that out for themselves. They will know where the market is. So what are we really worried about? Why are we trying to control that?
Potentially in relation to traffic generation, some activities were, I'm just putting that out there as being a potential impact. If you have a supermarket or something like that, and that obviously depends on the size. And we've heard from the supermarket
the
people
size
before,
will tend to determine.
but it could vary because of where it is and how big it is, what sort of effects there may be on the immediate catchment. And if there is an underlying concern about the smaller centres potentially undermining the function of a town centre, isn't that appropriate to be a strategic objective, such as the one we've got here?
I just can't see that would occur myself. These are now zoned areas. They weren't zoned in the past, but they were written into the ODP that there would be a small area of a certain amount that could be zoned. It was up to the developers to choose what that location was. But they are now carefully zoned. They're not large, so the chance of it becoming a problem would be.
So it's in your scenario, you're saying it's potentially not a problem,
yeah,
in relation to the town centre functions,
yes,
but in other places in the district where there is a potentially bigger amount of land available, and some certain
So
things
if they
might
want to do
undermine the
that-
function of a town centre, because the town centre presumably they're the community focus. They often the public transportation hubs, for example, they are the areas which have more frequent activities.
So the sort of places where I'm talking about are the neighbourhood, commercial neighbourhood centres.
Yes.
They are quite limited. I certainly take the point that a supermarket, I mean, the situation at Lincoln, they need more land. They will have to get rezoned, and the thorough assessment is then made. I'm talking about the relationship between sort of known small commercial centres and the KAC, and the fact that there shouldn't be limitations on that. But you can, whenever somebody comes up with a new zoning, you do all the proper planning assessment of it.
Okay.
And that would include economic impact.
So just going back to that particular objective, because we've been, we've got to look at the precise wording of this, and obviously we get advice from submitters and from the officers themselves. If you were to lose in accordance with the anticipated role, what would the purpose of the remainder of the objective be in terms of giving guidance to future decision makers?
Well, that is quite a good point, except that if it relates to pretty much size and location, if it relates to other things, no.
Okay. Well, thank you.
Kia ora and thank you. Maluna's green chair has covered quite well some of the questions I had.
No. And no further questions from me either. Thank you very much. No, we finished.
None.
No more
Sorry,
questions.
I wasn't sure where that was coming from. I was looking at him. I thought he was moving.
No, he
Thank
shook
you.
his head to me, so I'm assuming that's no further questions. Thank you very much.
Good luck.
Right, the next submitter on my list is Lloyd Bathurst.
I presume the microphone's loud enough.
Yeah, that's right. Well, good afternoon and welcome. We've read the original submission that you put in, so you don't need to reread that out to us, but you're very welcome to highlight what you feel are your key points for us. And then we'll see if we have questions for you.
Okay. To introduce myself, I'm a director of Rolleston Square Shopping Centre here, and I'm a resident of Rolleston. I guess my interest in this particular part of the proposed district plan stems from about 1975 when I'd left university and I was first self-employed. And I worked for one of the biggest land developers in Christchurch at the time, taken quite an interest ever since. And I don't think my submission has been accurately understood. And I guess I take the blame for perhaps not stating it as clearly as possible. So I want to do that today. Let me be clear, I'm not opposed to higher density living and I'm not opposed to public transport. What I am opposed to is telling people how to live and telling them how to limit their transport options whereby the economic and environmental costs are higher. My formal learning was an adult student at Lincoln University's BCom in Valuation and Property Management Studies. That's where I learned of one of my heroes, Jane Jacobs, who studied what actually works, and that's what worries me. She thereby became an expert at making great urban spaces, and I think that's very important. I'm also influenced by reading 40 years of economics, so I analyse planning by considering effects. And I also admire Bill Gates' How to Avoid a Climate Disaster, which I believe shows the way forward for democracies. I'm really frustrated that New Zealand has failed to provide affordable housing for a very large proportion of its population. I agree with our Human Rights Commissioner who stated that the current housing crisis was an institutional failure, frankly, a failure of democracy. I believe that Christchurch City's proposed changes to parts of the proposed district plan will continue or exacerbate that failure. The failure is a result of poor governance and planning, and that means all three levels of government and planners. I'm also concerned that one of the greatest threats to New Zealand's future is an increasing proportion of our best and brightest will leave and never return. We're also finding it hard to attract the best from other countries. I don't want New Zealand to become a less desirable place to live because we don't offer the housing types that people want at a price they can afford. To me, living in democracy entails or should entail choices and responsibilities. People should be allowed to live how and where they want to live and pay the environmental price in the manner of their choosing. People enjoy a better standard of living when they live in lower density areas such as Rolleston or Lincoln. It really is a great place to live and it has a very small environmental footprint. I was contemplating with someone earlier, I probably drive a car 2 to 3 times a week and that's enough. So it's a great way to live going forward. In Christchurch, lower density living's generally reserved for the very rich. That someone gets a disproportionate share of Greater Christchurch growth is simply because it provides a better standard of living at a lower price than is achievable in the city. Forcing land developers to increase the density of developments is going to lower the quality of living for those future residents. To my mind, they should be given a choice. If people want to travel by electric car or scooter or skateboard, they should be allowed. They should not be penalised for also having to pay for an unused public transport system. If people want to contribute to New Zealand's carbon footprint, they can pay the carbon cost. Remember that lower density living also makes it easier to generate your own electricity from solar. To me, it shouldn't be the viability of a public transport system that dictates the form and density of our development. That's essentially what Christchurch City is asking for when it states that an undefined integrated public transport system is required. The public transport system should be designed around our form and density of development and the choices we make to alleviate our carbon footprint. So Christchurch at the moment has a hub and spoke system with a single ring route. It actually suits a city of yesteryear when a much greater proportion of workers worked in the central city. But for Rolleston and Lincoln, the public transport system likely to be needed in the future is simply a connection to the city, possibly with minivans distributing from a common point in Rolleston and Lincoln. That system's worked for decades in many other cities, seems to be ignored in New Zealand. The links to the city are provided now, although it's by buses which are mostly empty, at a carbon footprint which is subsidised by Selwyn ratepayers. But in time and with a greater and older population, either buses or rail, or a mixture of both, possibly including the buses on the rail, should be viable. Christchurch City view of the proposed district plan seems to be based on an unproven belief that a public transport system can be desirable, dominant, and environmentally superior. In my view, that's undesirable, unacceptable economically, and environmentally highly unlikely. The only way I can see it working is if the planners make us all so poor that public transport is all we can afford. And do I need to explain that the Christchurch City submission looks like sour grapes, trying to handicap Selwyn from getting a disproportionate share of growth because more and more people are choosing to live in Selwyn over the city because Selwyn is a great place to live. Thank you.
Thank you very much for that. Let's see if we have any questions for you. Mark, any questions? Bet? Lindsay? Deborah?
I have one question. Just with regards to, you mentioned about those that choose to live in a lower density location, having the opportunity to pay the environmental cost however they choose. Are you trying to highlight that, and you mentioned about our carbon footprint, are you trying to highlight that our obligation under the Paris Accord to actually reduce our carbon emissions, because we are one of the highest countries in the OECD that actually have a high carbon footprint. But if they're prepared to pay that environmental cost, then they should be able to continue to actually cause that pollution.
I think New Zealand's actually in a fairly unique position to get down our carbon footprint very significantly. I think the opportunities are vast and we're only now starting to look at them. For instance, at Rolleston Square, we're looking at generating 2/3 of our electricity simply by covering all our roofs with solar panels. Pretty easy solution. New Zealand can get down to 90% to 92% renewable energy, renewable electricity when Tiwai Point goes to cover off the remaining 8%. Might be challenging for perhaps 2/3, 3/4 of that, but I think we'll get there quite quickly. Equally, we can generate electricity for transport very easily. It's just a matter of time. The technology seems to be at a pretty advanced stage now.
And just a further follow-up question with regards to low density, greenfield development, and the opportunity to actually manage our soils. Do you see, how do you see that evolving with regards to the growth of low density into greenfield and we've got our versatile soils or productive soils that we also have to manage.
I don't think New Zealand's going to run out of versatile soils in a very long time. They're just going to be a little bit further away from the city. So there's two ways you can do it. You can either squash everyone into the city and maintain your versatile soils on the outskirts, or you can use versatile soils a little bit further away because they exist and spread your cities out a little bit more, and we can enjoy a better standard of living. To me, it's that simple. And I'm not talking about a great change in the density that I'd like to see. I think somewhere closer to 12 lots per hectare rather than 16 makes a very significant difference.
Yeah, thank you, Mr. Bathurst. Just one question on the objective which has been suggested by CCC, which you're opposing. I think you mentioned earlier that you're not opposed to high density living, but you see this submission of CCC as being too directive. It's encouraging, I think, is of a form and density that supports the viable provision of public transport. So is your concern that it's too directive?
Yes, I believe that developers should have the choice to reduce density slightly. Right. This is increasing density. I don't see any need for that at all.
Right. No need at all for increasing density. Okay.
Correct.
All right.
They should have the choice. If people want to live in 16 lots per hectare as opposed to 12, that should be the people's choice.
Okay.
This is, after all, supposed to be a democracy. It's becoming less and less so.
Okay. I was going to ask if you could see any way to reword that objective, but I think you made it pretty clear that you're opposed to it. Okay. Is that right?
Indeed. Thank you. Sorry. Oh, sorry.
I did just have one question. So thank you for talking to us today. So just so I can get clear in my own mind, we're talking about 12 households per hectare, 16 households per hectare, etc. And I understand where you're coming from in terms of the comments you've made. In your mind, what does, do you know what that translates to in terms of a lot size for someone's dwelling, like 12 households per hectare versus 16?
12, if I remember correctly, 10 is 750 square metres average. Is that? Someone should be able to let me know. 12's obviously less. I think when we get to 16, we get a lot of 450s in the mix.
Sure. No, thank you.
That's pretty significant.
Yeah, no, thank you. I just wanted to check that we're on the same page with the calculations. Thank you for that.
So now you were further submitter on the Christchurch City Council's submission in relation to SDUFD 03. Our reporting officer has recommended no change to that particular provision, so I assume you support the officer's recommendation to not change that provision?
Correct.
Okay. All right, thank you very much for that. No further questions. Thanks for coming in.
Thanks.
Now, the last submitter for today is Fred van Slooten. No, just before you start, we'll need you to speak into the microphone, yeah. And so, yeah, good afternoon and welcome. Just before we hear from you, I just wanted to ask you a couple of procedural questions. If you had a chance to look at what we call the 42A report, which is the officer's recommendation report to us in relation to the submissions we received.
I've had a little bit of a look at it, yeah.
Did you read what they said about your further submission?
Yeah, and I wanted to comment on that as well.
Yeah, so you lodged a further submission, which are limited in scope. Further submissions are limited in scope to either supporting or opposing someone else's original submission. Your further submission doesn't appear to do that. Which original submission does your further submission actually relate to?
Well, effectively, it was a late submission. I've probably covered a few points off in what I've put up here and why. And yeah, I realise that is a bit of a problem.
It is a bit of a problem.
And yeah, I've got a couple of things in there and a couple of gripes as well, just in the whole process for myself. And hopefully just take that on board. And yeah, I guess if I go through that and we have the questions afterwards, it will probably
just a minute, because
answer some of those.
See, this is a semi-judicial process, so we're bound by certain procedures and that is set out under the law that we operate under. So your further submission, you're making on your own behalf to raise new points that don't relate to anything that's in an existing or an original submission. So you didn't read someone's original submission and decide you wanted to support or oppose it?
You know, some of them were there, some of them weren't. I mean, to be fair, I struggled with the whole process from the start, and you know, we're on our own with this. And if perhaps if you ever listen to that, then you might say, okay, well, what the whole thing? But believe we were given 15 minutes to have a chat, and I always like, if I make a point, that it helps others, and potentially if you ignore what I say today, that might help people in the future for the submission process, because it is pretty damn difficult for individuals to try and deal with something like the district plan and pick out bits and pieces from it that are applicable, when in most cases people won't even look at the district plan.
Yeah.
And that's, you know, it's a tricky one. It really is.
All right, well, you've taken the time to prepare a presentation for us, and we have plenty of time, so you're welcome to run through that. I just want you to be aware that because of the procedures that we operate under, we might not be able to give your further submission the weight that you would like us to give to it. And probably because of that, there probably won't be very many questions for you. But why don't you just proceed with your presentation, and then we'll take it from there.
Okay, no, thanks for that. Okay, so we own a dwelling in Cass. I don't know how many people here know where Cass actually is. Most of them do. So there is a shareholder of Cass Holdings and a committee member of the Canterbury Anglers Club, have been for some time. What I wanted to cover was, well, basically who is Cass Holdings, so we're the affected party, the location, submission process, the analysis of that 42A comments that you mentioned, the two designations on the railway corridor, grandfather clause, and the Anglers Club heritage designation. So just from there, you can see that black line or a little couple of odd shapes on the left-hand side. That is the area in Cass that is owned by Cass Holdings. So Cass Holdings was set up in 1999. The railways, obviously, back then, through the government, were told to sell off a whole lot of land around that bordered the corridors of the railways. And the land at Cass was a very interesting one in that they wanted to get rid of it. There was a number of houses and batches there. I was a member of the Anglers Club at the time who owned one of the properties, and everyone just wanted their own little patch of ground, but because of legislation, they ended up carving out about 4 hectares. There's 3 batch owners: Anglers Club, Cass Cottage, and we call it Cass Hilton, which is ours. And the only reason I got really interested in Cass was through the Anglers Club. So Now, the comment about the, the from strategic directions, and I can hardly read that myself, but it says other parties could potentially be prejudiced by the inclusion of further submissions. And by having a submission like that was put in, saying that it could prejudice other parties and what they are thinking and saying. But at the end of the day, Cass has a permanent population of 1. It's unfair to make submissions invalid on the basis that other parties could potentially be prejudiced by their inclusion because there's no one really that is affected by them. We are the affected party, and part of the submissions of it, or part of the process, was about reverse sensitivity effects, which means we've been affected by potential things that we may do on others, even though nothing's occurred. Now, I put this in because of the whole problem we've got. That, the submission process is very hard for the general Selwyn district population to work through and understand and make meaningful submissions, because obviously there's no point in putting together a lot of points. Now, unfortunately, because of the time frame I had to put that together, that's effectively what we did. The request for information pertaining to Cass gave a lot of items that may affect Cass, of which a lot of it we didn't really understand. And this was only later in the process. Andrew, Mactor and others have given information, and effectively the district plan comes out. There's a whole lot of stuff in it. We think, well, what the heck, it won't affect us, as most people think. And you don't get it spelt out to you as a layman, how it affects you. But the bit of land at Cass, there's so many things that would appear that affect us. It's huge. And the only reason I found out half that is because I'm working from 7 till 5. I've got other things on. I do voluntary work and other things. I don't have the time to spend hours and days looking through it. So my son had a look at some of the stuff, but again, later on in the piece. And he's the one who's actually picked up all these things that seem to affect Cass in some quite major ways. So it was really at the last minute that we threw this information together after really the submission process had closed. But how are we to know all of that information, how it affected us? The heritage process, okay, we were given the Cass Holdings was sent a letter about that saying, well, the heritage process is going ahead. You're in a club and committee arrangement thinking, well, what is all this about? You've got supposedly time to make submissions, but we didn't ask for the heritage process. No one even knew about it in the Anglers Club at all. And suddenly it ends up in the district plan. It's just fait accompli. The website itself, when it came out, Son was looking at it. I didn't have time to spend on it. He said, well, all sorts of problems. The layers didn't come down. And to find stuff like the noise control layer, which is really does affect us, he had no idea it existed until submissions had already closed and people were making comment about the noise. It was the only time we knew that how that affected Cass, because you had to go down a level, down a level, down a level to find it, because none of the layers were turned on when you looked online. And initially for months, for ages, that we couldn't even look at the district plan online for whatever reason. But I know that we were, again, some made comments about how many problems there were with the district plan online. We didn't get sent a hard copy, which you can open a page and say, that's 352, stick a highlighter over it, it looks like it affects us. Everything's online, and it was difficult, it is difficult. Here was something we got from the Selwyn District Council about the railway. We got here, which is one of the people who own property in Cass. Hi all, received this letter. I've followed it through the links while I was looking at something quite specific. Effectively looked at all that, couldn't find anything here that really affected Cass, just walked away from it. Here's a civil engineer. There was information that was dated back in 2000. So, this process for the small guy is bloody hard. Anyway, why we're passionate about Cass, well, there's an aerial view. And I showed in the first slide of, and the Cass Holdings part was the land on the right-hand side of the railway line. So I'll go into the various submissions that I put forward and why we've got problems with them. It's 4 hectares is the size of Cass. all falls within about 150 odd metres of the railway line, every bit of it. And I think actually that bit from your website actually is probably a bit narrow. Actually, I think that actually affects a slightly wide area. Anyway, so that's it. The bits cut out in the middle were because railway houses still existed, and that's how they sort of sliced out. So it's a very strange and unique bit of land. And with the noise one, and I'll perhaps have a look at it, that's why I'm making a point here. These are the views that we've got. This is a view from the Anglers Club looking across to the railway line, and you can see Cass Station there, which is obviously very famous by Rita Angus, the painting. So that's the view out of there. If you come down to what we're looking at from our balcony, there's a train going past. And that's one of the things what really sold us on Cass. I actually did 10 years working for the rail. I helped commission some of the coal wagons that go past. So it's passionate about the place. And then we come through to these noise objectives, and hopefully someone can actually understand this comment, because I struggle with it. It is designed so that a noise barrier consisting of a solid building, fence, wall, or landform blocks the line of sight from all parts of doors and windows to the state highway, road surface, and/or all points above 3.8 metres of the railway tracks. Now, I can't get my head around what that actually says about above 3.8 metres. I can see what it's trying to say, that between the tracks and 3.8 metres, you've got to create some form of landform. But when it says above 3.8 metres, I don't know whether a discussion on that now, is anyone?
See, it's not our job to answer questions, it's our job to
Okay,
listen.
no, well, I think there's actually, that's very ambiguous what it's saying. It's probably meaning you should have a wall or something. But anyway, you can imagine if, and that's about sound levels inside the house, which is why we're unhappy about that. I'll go back, because obviously if you put something, even if it is meaning below 3.8 metres, you're not going to see a lot of that, are you? There are obviously other bits in the Act or in there about determining noise levels and stuff in the side there, but this is reverse sensitivity stuff. So you're saying what this district plan is saying is that we've got to go and put all these mitigation factors if we want to possibly extend or change the building, that we've got to put all that in place because of reverse sensitivity. Why are we actually in Cass? Because we're interested in the railway line and the stuff that goes on. And the number of trains that go through there compared to the number of cars on State Highway 3 are poles apart. I mean, I don't know whether you can see how many trains go past here. Less than half of them go on the Midland line. So, for us, that's a huge bit of legislation that if we want to make any changes, then, it's going to make it super costly to try and change anything. You've got this other one, building and structure setbacks. Again, not fully conversant with it, but the minimum setback for all buildings and structures from each side of the centre line of State Highway 73 or Midland Railway line is 300 metres. The boundary for Cass Holdings is about 150 metres from the railway line. Now, reading that, take it, you can't even put a garage or anything like that. Now, when we bought the place, I rang the council, went through sort of, so what are the pros and cons? Yep, you can sort of probably move your house, you can do extensions, you can build a garage, all those things. Fine. So you buy it in good faith on that, for that reason. A comment like that says basically you can't do anything because you've got to be 300 metres away to build a structure. Notwithstanding, I guess you can probably still put in an application to do an extension, but if you do, then you've got to comply with the noise thing. Grandfather clause deletion. It's another removal of existing rights. Now, it's interesting with the grandfather clause, but Cass was subdivided between those dates that are in there for that to apply. Oh, we'll just delete that grandfather clause. Delete now. So that's protect existing rights. You're just taking that away, just like that, in one slash of a pen. And the last we talked about a week before about the heritage order. There is strong opposition from the Canterbury Anglers Club governing committee on there. They had a meeting about that. Really, obviously, again, it just stifles anything they have made future plans. We talked with Andrew Mactor about it, and he said, well, there's some money there for heritage buildings, and that's fine, and our club certainly respects that. But there's already been additions that weren't, I think, picked up in there, and there was building consents put in for that, and they were done very tastefully, to be fair. But it imposes a lot of restrictions on a club, and there's already changes there. Now, the point is, I mean, that was just brought upon the club by inaction. It wasn't brought about that some member said, oh, we think it's a good idea. No one in the club asked anyone to put that in the heritage listing. And believe that most information for that was actually pinched off our own website. And then effectively, I won't say used against us, that's not quite why you put heritage buildings up there, but it's in our club, I mean, we're asset rich, cash poor. So if we want to make an extension or anything like that, there's grounds there, I guess, within that to do it, but it's an awful lot of work and a lot of cost. And all we're asking for is a status quo. Through that photo in there, why we love Cass from, family, got 2 boys. It's our sort of place away from the rat race of, Christchurch. I mean, we love the place. The boys love it. They stayed there over lockdown. That's how much they like the place. And all we're trying to do is really retain what we've got. I mean, we've got, love to make some plans to make some extensions and make the place a bit more sort of user friendly, because, it's sort of a dwelling. It's we can certainly live there and possibly in the future. But with all those other restrictions coming in this district plan, it makes any changes or improvements nigh impossible. Now, yeah, we're late with the submission. And why? How are we meant to pick up that stuff through just reading the papers and going to work and doing your normal stuff? It's not possible. And it was only picked up because my son had the time to look at the plan at the time. And even that didn't happen straight away. So yeah, we're between a rock and a hard place. I mean, I appreciate you guys listen, and girls. And I don't know where to go with this, to be fair. But I'm really upset at this, absolutely upset. And so some of the other holders, because I mean, we're talking, the other dwellings is owned by 2 families and their children that go there, and the Anglers Club, and the Anglers Club had an association with it for likes of since 1977 when they bought it. My association goes back to the mid 1990s when I joined the Anglers Club, but this is stuff to make, for tears to see the restrictions. Now, what we asked for is that noise zone and all the rest of it be taken out for that side of the railway line that affects those areas. And we know the natural landscape plans and all the other stuff that goes with it, with the high country outstanding zones, they all just put more and more restrictions on the area for there. And, it's there to look after the high country, totally agree. But, I don't know where to turn, really, to be fair. I mean, we see other destructions occurs on farms there, where they've bowled over the likes of Matagari and stuff. They've been given just I think it was a $5,000 fine. The ground's now green, and the lakes around there, Grassmere, Pearson, they're on the brink of actually failure, as you probably well know. We're not farming, we're not dairying, we've just got a couple of houses there. We just want to protect our rights. And that's all I'm asking. But I realised we were late with the submission. Why? Because the system effectively let us down. We didn't get sent from the council by people. We didn't get sent a letter and say, hey, you're going to be affected by 1, 2, 3, 4 items that are nice and clear. When we requested that information to say, how does it affect us? We're just given a whole lot of series of numbers on a website that was really hard to follow. How were we meant to easily be able to put up a good argument, say we don't want those things in time, when it's near impossible to get the information without forking out thousands of dollars to get lawyers or planners to go through all that? Now, okay, the council did say, yeah, come and we can come and see you guys and people to talk about it. But time-wise, it's absolutely struggling when we're working. The process for the small guy is broken to be able to be effectively deal with all the things that affect us at Cass. I mean, it might be, for other people, it might be just one item that affects them, but for us, there's a lot of things that kick in. Yeah. I mean, appreciate you listening to that, and hopefully you can take that on board. If you can make changes to help us, I would love that. If you can't, look at the process for next time to help others that are in the same boat, because there must be lots out there that don't even know that these changes or how they affect all the people in different ways. People just don't know, because you can advertise as much as you like, but you can't just look on a PDF the size of the district plan and say, hey, that affects me, I'm unhappy about it. And if you look at the number of submissions that are coming for people that have got the time, mostly companies, it's unreal. There's hundreds, millions of dollars spent, I guess, in corporate time on this district plan. And how much does it cost a few people to be here? I could imagine that there's thousands of dollars an hour here.
All right, well,
Yeah.
I think you've made your concerns pretty clear to us. And we've discussed the procedural problem that we might have with your submission, or that we do have with your submission. I'll just see if we have any questions for you, starting at, can't remember I'm up to. Mark, any questions? Vet, Lindsay, Deborah, Gary?
Just, I haven't got a question, just a couple of observations if I can, Mr. Van Sloot. In terms of the heritage order that's apparently been imposed over the Canterbury Anglers Club, I presume that no one in the club was aware of that either, haven't lodged a submission on that. Is that what you're saying?
No, we were made aware of it. And in a club, obviously time rolls by pretty damn quick. And then it was only when we were sort of, or Sun was reviewing the district plan that we made aware of it. So we didn't submit for or against it, but we were never given a notice to say, hey, your time's running out, you need to make a submission either way.
All right. Yep.
So again, if the council had done that, we could have jumped into action. But as it was, you've got a committee, they're discussing stuff, and it moves on. So no, we weren't made aware of it at the start.
Okay, and I guess the only suggestion I was going to make is if you're not fully aware of what the heritage provisions mean, and I don't know because we haven't got to that point of the hearing yet, but if you're not fully aware of what that actually means for the building, I invite you to talk to staff.
Well, we have done. I've talked with Andrew McTurn and said that some of the pros and cons. And yeah, it looks like there's more cons than pros. So, and the status quo staying as it is not going to really deteriorate the building if something were to come in the future.
Right. And just the other point, that you've made some comments on the noise rule regarding railway noise.
Yep.
It's possible, and I can't preempt it, but it's possible we may be revisiting that when we come to that part of the plan. There might be submissions on that very point, not so much for CAS, but just the general rule that requires, screening and so forth. So it's just an observation. We may yet come back to that in another forum.
Yeah, because I mean, when I was given the information that I was talking today, it's about the strategic plan. I had no idea, and it took me some time to work out what I was actually meant to be presenting. And it was again when I rang officers, they said, well, actually, because of the fact that it might be a non-complying application or whatever, that you're going to sort of talk about everything at once. So it was a pretty hurried sort of throw some notes together and put it together, because I knew that noise and the others were months away.
And no further questions from me either, but thank you very much for taking the time to come in and talk to us.
Excuse me, Rob. So it may not be scope to take this one into consideration, but on those provisions which you have mentioned, there may be scope inside other submissions to take that.
Yeah.
So can I ask then, if there is, how will we be informed about that?
Yeah, probably if you any further process queries, maybe after this hearing concludes, which will be in a couple of minutes, you can talk to the officers about that. They can help you with that rather than us as a panel.
Okay, thanks.
Yeah. Right, thanks very much. So that brings us to the end of proceedings for today, and we adjourn until 9 o'clock in the morning. Thank you.